Good morning, everybody. Happy Thursday. Welcome to TCF Live. It's nice to have you all here with me this morning. Let's get started in Michigan. A certain Judge Brian Oakley.
The attorney.
Yes.
Excuse me. Thank you. All right, so you've got a plea agreement here. Let's see what we got. Oh, you want to adjourn this?
Yes.
Okay. Working on getting your license straight. What do you got to do?
Go up against the Secretary of State Board.
Ooh, you got anything scheduled?
Yeah, I was kind of seeing how what was going to happen.
All right, the problem is, I'm going to give you a month, right? Well, a little bit, about a month. I'll give you till March. The problem is this might be a month-long process, and I'm not likely to want to kick this can down the road that far. So find out what you can, come back and see if you can come up with a plan. All right? So Heather, we're just going to adjourn these till that March date.
Do you want March 26th then to give?
Give them extra time. Yeah.
Okay.
Yeah. So here's what I tell everybody that's in your position. Hire an attorney if there's any way you can possibly do it. It's just so many people, they set up the hearing, they go to the hearing, and they end up just wasting their time. If you hire an attorney that specializes in license restorations, number one, they'll make sure you don't even bother going to a hearing until you got all your ducks in a row. And they also know what ducks need to be in the row. All right. So yeah, I know it's a money thing, but if you're like everybody else in your situation, the main reason you got to get your license is because you need to get to work or you need to get to a better job. Right. So in the long run, I think you're money ahead if you can come up with the money. I mean, even if you got to borrow it from grandma or something. What I would suggest you do in the next couple of days is start making some contact. Where do you live? I didn't look at your address. Livonia. All right. There's a lot of attorneys that do a lot of driver's license appeal division stuff here. So what I would do is I would just randomly call some attorneys that are close and convenient for you to go to and say, look, I'm looking for a driving restoration expert. Who do you recommend? Because, you know, the guy that just does, you know, criminal stuff, but doesn't do DLAD stuff, he's not your guy, right? You want to find the attorney that does driver's license restoration, all right? And then just sit down with them for a consultation. They'll tell you what they'll look at your situation. They'll tell you what you're looking at timing wise, what ducks you might have to get in a row before you bother going in for a hearing. You'll have a better game plan. Even if you decide you can't afford them, you'll have a better game plan when you come back and talk to them. All right. Good luck. All right. Is it Furillo? Come on up, sir.
The half or
F. You're going forward today without an attorney and you're doing a double parking. All right, so we're going to dismiss 3 charges from January 17th, and you're going to pay $300 for double parking, right? Can you do it today? Pick a due date. Look at the calendar. I'm pointing at the calendar. I'm sorry. I didn't expect you to read this. Yeah.
Protocol by February 28th. Is that fair?
20th, if that gives you enough time.
I said 28th.
28th? Well, no, because that's a Saturday. Can you do it by Friday, the 27th? All right. So I'm just going to give you until the 27th. We're not going to do any paperwork until you come in with your money. Then we'll dismiss the actions. Because if you don't pay your money, then all these charges are back on the table. Make sense? Questions? You're good to go. Hold on just a minute. I gotta answer her question because if she ain't happy, man, we'll do it on C. Go ahead.
I've seen you before. You recommended me go to Michigan Youth Challenge Academy. I'm glad you did that.
That was a while ago. Yeah. Tell me, were you on my docket?
Yes, sir. I'm seeing.
Yep. Tell me. So how long has it been since you did the challenge? And how did it change your life?
More discipline.
Man, that's huge, isn't it? That's huge though. So what do you do now?
I work at a shop, mechanic, good shop manager.
Where at? Good. How long have you been there?
2 years.
Good. Yeah. So did you get your diploma from them?
Yes.
Yeah. So how old were you when you went?
6, 7.
Okay. All right. So 5 months, done with high school, moving on. Yeah. Good for you. And thanks for sharing that. You know, because as you can imagine, I'm still trying to talk kids into going because I still think it's a great opportunity. Yeah. Where you living?
Sumter.
Sumter. You mind if we reach out to you, maybe if we think you can be a salesman for us? To convince a kid to go? So, no pressure, no pressure. Because sometimes I'd like to just be able to say, hey, I can let you talk to a guy that's, what are you now?
What's that?
6 years, you're 6 years out of the challenge. All right?
Not a good talker, I could try.
No, but if all you do is say, it changed my life and this is how, because it gave me discipline, and without that, I don't know where I'd be. Or you might have a good idea. Without that, here's where I think I'd be. Right? Would you just get, name and phone number?
That I have his number.
Yeah.
7527055.
Yeah.
So Scott would be the one reaching out.
Yep. Yep. And make a note so we share it with Scott that, Scott's our new Christine. He just started what? September?
No, didn't he start January? Or?
Yeah, January. That's right. Yeah. Yeah. We hired him. Yeah. And just let Scott know that this guy went through in 19.
Yep.
Yeah. And he might never call you. I just like to have tools in the box. Okay. All right. Great. So downstairs, no, actually, you don't have to do anything downstairs. Just come back between now and the end of the month with the $300
Just downstairs.
to pay. Just come back. They'll put your name in the computer and you're good to go. All right. What did I say? I'm going to do that on the C ticket, Heather?
Yep.
All right. You're good to go. Have a great day. And once again, thanks for sharing that.
And how long does he have to pay? So I put it in
Till the 28th.
All right.
This month.
February.
Yep. Hey, when things slow down, I got a couple rubber stamps that need some ink.
Okay, no problem.
I can get through today with it.
Our expertise in that's Chip.
Oh, is it?
He loves that.
He was standing right here when I told Heather I was gonna have you, you do it. You guys have just been taking it to town. Didn't see that?
All right, good morning once again, everybody. Welcome to TCF Live. Happy Thursday. As Judge Oakley looks at getting somebody to re-ink his stamp pads, let's stay in Michigan. Go say good morning to Judge Dad.
Lobenberg, have a seat at this table. Come on up to the podium, ma'am. Zachary Hines, have a seat at the table. Your name? All right, you're charged with a violation of probation. I took your plea. Let's see. I took your plea under section 771. I need Jessica. You pled guilty to failure to report. Hang on 1 second. This is the new one. This is a new one.
Yep.
Oh, it's the violation?
You're charged with failure to complete the economic crime prevention program with Class A Training Center. That's count 1. Do you understand the charge? Are you tired?
No.
Okay, I just wanted to make sure. Count 2, that you failed to pay your fines and costs as ordered. Do you understand the charge?
Yes.
Count 3, you failed to provide proof of completing 32 hours of community service by January 31 of 26. Do you understand the charge?
Yes.
If you plead guilty, if you're found guilty, that would be 3 more technical violations. Your probation could be revoked. You could be incarcerated for 90 days. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights revocation and probation form?
Yes, I did.
If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial of any kind. Do you understand that?
Yes.
You have the right to an attorney. I'll be happy to provide you with one at public expense if you would like one. Would you like a lawyer to represent you? Or- I'm going to ask you how you plead now. As to count 1, that you failed to attend the economic crime program with Class A Training Center. How do you plead?
Yes.
Did you fail to attend that program?
Yes, I did.
Count 2, that you failed to pay your fines and costs as ordered by January 31 of 26. How do you plead?
Yes.
You failed to pay your fines and costs as ordered by January 31 of 26. I'm asking, did you fail to pay all of your fines as you were ordered to pay?
Yes, yes,
Okay, but you failed to pay your fines and costs as ordered, correct?
yes.
Count 3, that you failed to provide proof of completing 32 hours of community service by January 31 of 26. How do you plead?
Yes.
Did you fail to provide proof of completing your community service by that date?
Oh, yes, I didn't turn it in by the day.
Anybody forced you to plead guilty?
Huh?
Anybody forced you to plead guilty?
No,
I'll accept your plea. I was probably too nice. I'll accept your plea as to all three counts. It's-
I could pay the fines today and I got the community service paid that I didn't turn it in on time, but it was completed before the 31st.
You're not taking me very serious.
No, it was done. It was done.
Listen to what I'm telling you.
Hmm.
You ran here on violations on December 17 of 25.
Yeah.
I did nothing. I didn't assess any costs. You had a failure to report, failure to complete community service. I told you to complete your community service and provide proof by January 31, pay 200 by December 23 of 25, the rest by January 31 of 26. And I told you again, if you didn't have the money to call the court, we'd go on Zoom, I'd give you an extension. None of that happened.
Okay, I do have a lot going on. My daughter's still in the hospital, so that's why I just couldn't sink in. And the day I got done, I had to go straight to the hospital, stay there with my daughter for about 2 weeks.
For 2 weeks?
She's been there since December.
Is she still in?
Yes.
She's been there for 2 months?
No, a year and months, like last December.
Well, December of 25, right?
December 2.
She's been in the hospital for 14 months?
Yes.
I don't remember us talking about this.
I did talk about it.
Your name?
Just the quote on, we
Re-
did. talk about it.
Remind me, remind me.
Yes, her daughter has been in the hospital. She reminded you the last time in her hearing that she's been in the hospital for over a year now. She did provide proof of the community service today. And based on the letter, it was completed prior to the due date, but she did turn it in until today. But those hours are now completed and confirmed.
What about the economic crime program?
That class is not in.
She did everything.
She did everything but the class at this point. She said that she has the money to pay today for her balance. Otherwise, though, the community service is done. The only thing left is the class. Her case was taken under the 771 delayed sentencing status. She's set for prosecutor review next week, February 19th.
It's then the program won't be done.
No, it will not. I don't know when the next class is offered. I know the last one was January 18th and she didn't attend that.
I placed her on probation on August the 28th, so she should be coming off February 28th, true?
Correct.
So I'm gonna extend probation for 2 months until April 28th of 26. There's additional costs of $50. Additional probation fees of $40. Heather, I'm gonna need a new review hearing date sometime before that. And you have to make sure you complete the Class A training center, okay? I don't remember talking about your daughter, so I didn't make any notes on it. I don't know why. Complete the program at Class A, and why don't you give me a date, Heather, like in, let's see, we're already mid-February. Why don't you make it second
April,
week?
Judge, or,
Yeah, second week of April or so.
okay, we could do April 9th.
All right, we're gonna make it April 9th. Review hearing will be April 9th at 8:30, okay, ma'am? You're gonna pay all your fines now, right?
Yeah.
All right, I'll make a note. You're gonna pay all your fines costs now. Proof of completion of community service provided. I wish you well. If you do everything when you're supposed to, you're gonna end up with this case dismissed. It was taken under 771. You gotta have everything else done though, okay? April the 9th at 8:30 will be your review hearing date. I wish you well. You'll go down the hall, you'll get your dates and we're all set.
Okay.
Good luck. And good luck with your daughter. I'm sorry you're going through that. I don't. Lobenberg. Jarek. Jacob Robert Lobenberg. Is that you? Oh, where's Lobenberg? Oh, I see. 260-647-525 A and B. Okay, this is Judge Hessen's, I'm just gonna send it over there for her, okay, Heather? I believe it has her name on it. Is Lobenberg her case?
What's the case number on that again, Judge?
They keep sending them in here, 260-647-525, 260-647-525 A and B.
Let me
Jen.
double check on that.
Taken Judge Hess.
Yes, that is hers.
Zachary, okay, good enough. I'm gonna send it down there. Zachary Ryan Hines, 25G306737 A and B. All right. Where's your lawyer?
Not know.
Oh. Okay. Okay. Well, we're gonna have to wait for your lawyer. Okay, I'll pass the case. You can relax. I didn't. Shoshana Rochelle Curtis, 26T647-504 A and B. Could I have Zuko seated at the table here, my right, your left? And you can come up here, Ms. Curtis. Your name? Nice and loud for me. You're charged with driving on a suspended and defective equipment. You have the right to an attorney. If you want one, I will give you one. Would you like a lawyer?
No.
I'll arraign you and then I'll send you to the prosecutor. I'm gonna need that one sentencing with Mr. Gamber. You're charged with
Miss
that.
Curtis up here, Tashana Curtis.
What's
Is that
that?
who you- Is this Tashana Curtis? I'm sorry that you have at the podium.
Yeah.
She has 2 warrants that we're working on right now also.
All right.
And I believe it does look like though they are Judge Hessen, so I'm not sure if you just want to send her over there or when we're done with them. But just to give you a heads up.
All right, thank you. Ms. Curtis, you're charged with operating a motor vehicle on January 18 of 26 in the city of Trenton on Fortner West at 1:16 in the morning. They think you had defective equipment and a suspended license. That is a misdemeanor driving on a suspended, punishable by up to $500 in fines, 93 days jail costs, or all of those penalties. Do you understand that? Nice and loud.
Yeah.
Did you sign the advice of rights and read and understand the rights? If you plead guilty, you'll be giving up all those rights and we're not going to have a trial of any kind. You understand that? Yep. You still wish to waive your right to a lawyer? I'll enter a not guilty plea. You got to show up in court. Why? When was she scheduled for court that she failed to appear on?
October 12th of 2022.
Oh, geez, I don't want to rush you here. What are you doing?
Bill Court, where?
Here, this place. You were supposed to be here in October of 22. Well, don't sound so aloof about it, okay? You're not endearing yourself to any judge when you pull that kind of nonsense. You're going to be arraigned on those warrants next door. $500 personal bond. You're lucky you're getting a personal bond. You work? What are you acting like this for? Like I don't recall, like it's not a big deal. Like I forgot to pay my water bill that was $3.13. Young lady, don't play games. Judges don't like games. You want to play games? Go to the store, buy Scramble or Trouble or Monopoly or whatever else. Don't play games in here. You got it? Good. You'll go meet with the prosecutor. Either way, you'll come back in front of me and then you have to go next door to Judge Hessen. And she will arraign you on those charges when they cancel the warrants. Good luck. Zuko, either way, you're coming back in front of me, young lady. Joe.
Morning once again, everybody. It's TCF Live on a wacky Thursday. Good to have you all here. Let's move on. Go to Washtenaw County. Judge Simpson and his hit that everybody loves. Bond continues.
There's one right there in the blue.
I'm going to grab everyone else, Your Honor, real quick before we start, if that's okay.
Well, I've already started.
I understand. We want to make sure that they're all here.
Oh, okay. So you're the attendance monitor? All right, go ahead. Go do what you do. Mr. Cook.
People believe any potential conflict between this honorable court and the office of the public defender. People do not believe that any such conflict exists. We make this waiver in the avoidance of holdout.
Thank you, sir.
Morning, Judge.
Mr. Fuse.
Thank you, Judge. We likewise do not believe that any conflict of this honorable court for the cases this morning, but should one arise, we will waive said conflict and please ask this honorable court to hear all of these cases.
And the court for its part also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the cases of the people versus Jesse Ivy.
Alex Keselowski.
All 6 cases.
Oh, I apologize.
Where's my
It's
cheat
Mr. Gaddy. It's Mr. Gaddy.
Sorry. For Mike.
Right on. No. Mr. Gaddy.
That's a great question, Judge.
Okay.
Oh,
You were the one responsible to get everybody. No, you failed. Go ahead, Mr. Feaster.
thank you, Judge. Mr. Feaster, first is public defender on behalf of Mr. Ivy standing.
Mr.
Gaddy.
Mr. Ivy, can you state your name, please, sir?
Jesse Ivy.
All right.
Thank you, Judge. And speaking to APA Chabalowski, sorry, I believe we're waiving this matter up to circuit court for further resolution.
So he's doing a waiver on all of these.
That's my understanding, Judge.
Is that your understanding, Mr. Ivy?
Yes,
I didn't hear you, sir.
yes,
Yes?
yes.
Okay.
Okay.
Sir, you're waiving your right to a preliminary examination in all of these matters. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes,
You understand that you will not have that hearing and that you'll proceed to circuit court for further resolution of these matters.
yes,
People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on all, I believe, 6 counts.
Thank you, Judge. Well, we will waive reading and ask the court to stand mute, Your Honor.
Defendant having waived formal reading, standing mute as to all counts. Court will enter a not guilty plea. Pretrial in these matters will be set for
March 11th at 1:30 with Judge Conlon.
March 11, 2026, 1:30 before Judge Conlon.
Thank you, Judge.
Thank you. Bond in these matters will continue. Thank you. You'll take them.
Yeah.
Court does call the case of the people versus Derek Jones.
Morning, Your Honor. Joy Fancy, Assistant Public Defender representing Mr. Jones. Your Honor, I was just approved yesterday to be able to schedule a visit to meet with Mr. Jones. I'm asking for an adjournment and I'm filling out the green sheet right now.
Mr. Jones, can you state your name?
Derek Jones.
All right. And you were unable to schedule a visit, is that what you're telling me?
Yes, Your Honor.
Well, probable cause conference in this matter will be adjourned to March 5th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you, sir.
I do have a question for you, Honor.
Court does call the case of the people versus Demarion White.
Killwall was distracting me, Your Honor. So, good morning, Your Honor. May it please the solemn court, David Burgess on behalf of Demarion White. It's appearing via Zoom from the juvenile center, Your Honor.
Mr. White, can you state your name, please?
Demarion White.
Thank you. What are we doing?
Your Honor, Mr. Childers and I are speaking regarding an ultimate resolution in this case, but we're asking for a little more time. So an adjournment of the PCC is requested.
5th or the 12th, work better for you?
Either is fine.
The 5th is fine, Your Honor.
Probable cause conference will be adjourned March 5th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor. Judge, Your Honor, can we just approach on a collateral matter? I apologize. It'll be quick.
All right, quick sidebars are never quick there. Speaking of sidebar, though, tonight on this channel, 8 p.m. Eastern, 5 Pacific, we will have sidebar. I don't have it posted yet. I'll post it after the show, but that does not preclude you from joining us anyways. 8 p.m. Eastern, 5 Pacific. We should have a good discussion tonight. We'll stay in Michigan. Let's go see a certain Judge Middleton.
Good morning.
Good morning, Mr.
Good morning, Your Honor.
Thank you for coming to Centerville today by Zoom. You've logged in as iPad telehealth. Are you Richard Elliott?
I am Richard Elliott Jr., Your Honor.
Give you a proper name.
I'm sorry.
I'm gonna change your name here.
Okay.
Mr. Wojciech, are you here on behalf of the defendant?
Yes, Your Honor.
All right, well, we'll wait for the prosecutor. I don't know that we've ever crossed paths before. St. Joe County and St. Joe are not very far apart, but we don't often touch and share cases.
I get a few calls here and there since I'm in St. Joseph, Michigan, with someone looking for an attorney in St. Joseph
Well,
County.
occasionally we'll have people actually show up in the wrong courthouse. And to further complicate things, as you know, then we have St. Joe County, Indiana.
Yeah. Yeah, and we're pretty close to that too. We border that with, South Bend area, so.
I start every morning by giving the first line of a song. I call it a shared moment of humanity, but I didn't do that on this record. I didn't figure the Berrien County court needed to have my first line of the day on their feed, so I did it separately.
Sometimes one of the judges here will do trivia from his calendar, and tonight's our Bar Association trivia night, so I'm looking forward to that.
All right. All right, Courtney O'Malley is our prosecutor, and she at one time worked here for me as an intern in the prosecutor's office about 28 years ago, and so it'll be nice to see her.
So while he's waiting for the prosecutor, just to make things clear, this is a special assignment case for him out of Berrien County, not his court. I think there was some conflicts of interest, so they had to reach outside for a judge, and they've got him.
Good morning.
Good morning, Your Honor.
It's nice to see you.
Nice to see you. I'm sorry, I'm not very good at Zoom.
All right, well, we do a lot of it here, so thank you all for agreeing to do this by Zoom. Let me call the case. This is the Berrien County matter of People versus Richard McNally Elliott Jr. The file number is 250185558. I think the suffix is SM, which stands for statute misdemeanor. Mr. Elliott is here by Zoom. He is represented by attorney Ryan Wojciech from Berrien County, and prosecuting attorney Courtney O'Malley Septoski is here on behalf of the people. I've been assigned to this matter by the Michigan Supreme Court because the judges in Berrien County have a perceived conflict of interest and they have disqualified themselves, and so I've got it. And so I get several of these a year, and so does everybody else. So let's start at the beginning. Mr. Elliott, you were first charged with a misdemeanor offense of domestic assault and malicious destruction of a building. It's alleged to have occurred the day after Christmas, December 26th of 2025. Those are both misdemeanors. However, the prosecutor filed an amended complaint, adding a felony charge, which changes the procedural posture of what we need to do here. So let me inform you of what the charges are. I think you probably know, but let's start at the beginning. It's alleged that on or about December 26th in the city of Buchanan, that you did make an assault upon Richard McKinley Elliott Sr., who I believe to be your father, with a shoe, an UGG, but without intending to commit the crime of murder. That's commonly known as felonious assault or assault with a dangerous weapon. It is a felony punishable by up to 4 years imprisonment and a fine of up to $2,000. Then we'll go back to the original domestic assault charge. Domestic assault is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. This particular charge also would prohibit you from using or possessing a firearm for 8 years. The other charge is malicious destruction of a building over 200 but less than 1,000. They allege that on that same date and same place that you damaged a building at One Park Court that belonged to McKinley Elliott Sr. and did damage more than 200 but less than 1,000. That's a misdemeanor also, but this one's punishable by up to a year in jail, a fine of up to $2,000 or 3 times the value of the property. I've never ever done that, but the law does allow for it. All right, so I got this, and we had some difficulty coordinating all of our time schedules, and I appreciate everybody being here. I've been informed by my administrator that Mr. Elliott, you're presently in a treatment facility, is that correct?
Yes, Your Honor, that is correct.
Where is it?
Kalamazoo, Michigan. Called Center Point. It's an extension of Pine Rest.
All right. And Mr. Wojciech, I know you and Miss O'Malley, that's how I'll call her, because that's how I knew her, and she was 25, have been talking about this case. I've heard maybe we're gonna push it out a little bit. What's your preference here?
Yes, Your Honor, that's correct. I think we have a strong likelihood of resolving this matter, but we'd like to see some of these moving parts settle in a little bit. So I would just ask the court if we could reset the pre-exam conference and waive our 21-day right to, the preliminary exam within 21 days of arraignment. And if we could just reset this matter possibly for 3 or 4 weeks, and hopefully by then we could have a resolution to present to the court.
Prosecutor O'Malley, is that agreeable with you?
Absolutely, Your Honor. We would like Mr. Elliott to remain in treatment. That's our biggest concern. So I have no objection to moving this so that he can continue his course of treatment. I have been in touch with the victim who also agrees with that.
Mr. Elliott, you have a right to have this hearing, as your attorney said. I thought it was 14 days, but he says within a certain time period from your arraignment. Here, we're going to adjourn it while you continue with your treatment, which I don't have any objection to, and apparently nobody else does. Do you have any objection to continuing this matter?
I have no objection.
All right, well, let's find a date that works. They'd be gone for a little bit in February. How about Wednesday, March 11th at 9:30?
That works for me, Your Honor. Would that also be by Zoom?
Yes, it would, if you guys agree.
That works for us as well, Your Honor, if it's by Zoom.
Mr. Elliott, You do have the right, obviously, to be present at all proceedings. You're present here by Zoom, which works out good. You're in Kalamazoo, the attorneys are in Berrien County, and I'm here. So Zoom is tailor-made for this kind of a circumstance. At some point, this will probably require me to come to the courthouse in Niles. For example, if we do work out a plea, and I impose a sentence, I would probably come there and do the sentence at Niles or St. Joe, depending on what works for the Berrien County people. But right now, we're just getting all on the same page, agreeing to the continuance and picking a new date. Do you have any objection to doing this by Zoom like this? Mr. Elliott?
I do not, Your Honor.
All right, and we're going to do the next one by Zoom too. I'm gonna give you a little heads up. Your attorneys probably shared this with you. In a domestic violence case, and they come in a lot of different sizes and shapes. They're often domestic partners, husbands and wives, boyfriends, girlfriends, wives and wives, but they're all sometimes family members, people that live in the same house. There is a special statute that allows a court to place a defendant on probation for a domestic violence charge. And if they successfully complete that probation, the charge could be taken off your record and be a non-public record of conviction. So I'm not sure if that's what they're working toward, but that is one option that could resolve all of these. So we'll see where we go. Everybody seems quite positive about it. They seem positive about your seeking treatment. And I'll see you by Zoom on March 11th at 9:30 a.m.
Judge, can I just ask one quick question? If we have a resolution worked out, will you accept that by Zoom, or should we let you know? And
I'll take
schedule
the plea
something?
by Zoom, but if I'm
Okay.
gonna do the sentence, I'll come over there. If it is a domestic violence case, theoretically, the law says the case needs to be continued for 10 days, at least to give an opportunity for victim input. And I don't know if Mr. Elliott Senior would be there, but if we work that out, I'd certainly be willing to take the plea on March 11th. And then I may come visit all of you. Maybe the snow will be melted by then.
Hopefully.
If I set it for May. Anyway, we'll continue to work on this. Mr. Elliott, continue to do what you're doing. Stay in contact with your lawyer. There are bond conditions in effect that prohibit you from having contact with the complainant. So you're prohibited from having contact with your father, but we'll see where this goes. But for the time being, those conditions are in effect. This case is assigned to me, and I'm certainly willing to accept it. So I will see you all on March 11th at 9:30. So we'll we'll let Mr. Elliott go.
Okay, thank you, Your Honor.
Everybody stick around for a minute. I'm gonna stop the live feed. And
all right. As he said, he stopped the live feed. Let's go down to Florida. Wade Mercer, first appearances.
Ms. Johnson, good morning, ma'am. Ms. Johnson, you're here because you've been accused of one count of mischief. The officers made a charging decision thus far as a misdemeanor offense, and you do have friends or family in the courtroom on your behalf. I'm going to appoint the public defender's officer to represent you. I'm going to tell you that there is probable cause in the complaint, and I've also looked at your criminal history, so I'm somewhat familiar with that. And Mr. Mitchell, on behalf of the state, I think that you just advised me that you want time to look at this one. Is that correct?
Yes, Your Honor. We need time to review the total damages, see if it may qualify as a felony.
Okay. Mr. McDaniel, anything on behalf of Ms. Johnson? Your Honor. So, Ms. Johnson, the state attorney's office has the right to take a look at the case and interview the alleged victim and decide if it's going to be a felony or not, ma'am. You're still entitled to a bond today. I'm going to set you a bond, but that bond is based in part on your criminal history. Your bond's going to be $3,500 cash or surety. If the bond is posted, she has the right to be released. So I'm talking to your mother now. If it's posted, she has a right to be released. That's the law. If it's not posted, then what's going to happen is Mr. Mitchell's office will get the complaint in, they will review it, they will talk to the alleged victim. The threshold for a felony in criminal mischief is $1,000 damage. So if they have a good faith basis to believe that there's at least $1,000 damage, they may decide to go with the felony charge, which opens up a lot more treatment options. I know that you had, Mr. McDaniel's text, or you had said that you thought Florida State Hospital is where she needs to be. That's not really an option from a criminal sentence in a misdemeanor court, but it could be in a felony case. So they'll need time to look into that. In the meantime, she's got the right to a bond. Ms. Johnson, you do have a condition of no contact with the alleged victim starting at this point going forward. Ms. Johnson, we're going to give you a notice for your court date, ma'am, or the jail will give you a notice. That will be March the 2nd.
Yes.
At 9 a.m. That's if it stays in misdemeanor court. If the state decides to take this case to felony court, it would be a different date. Ms. Johnson, do you have any questions?
No, sir.
Ma'am, the court- Mr. McDaniel would say?
I was gonna say, Jake, those Cybertrucks are advertised to be indestructible with scratch proof and can't bust windows. I don't know if there's gonna be damages that you think they are, because they're supposed to be indestructible, and just to let you know that. I mean,
Sir, it was my car.
I know it was. That's all right.
Okay, but somebody was driving
It's all
and
right.
they free and I'm here today.
That's all right.
All right. So we'll see you on that court date. Ma'am, wish you the best.
Barbara, thank you for the $5. Prayers for Wahoo. I agree. For those of you who don't know, Wahoo, a regular here on TCF, his sister passed away a few days ago. Also, if you're a person of prayer, my ex-wife, the mother of 3 of my children, is in surgery right now as we speak, getting cancerous tumors removed. So prayers for her as well. Let's continue with Judge.
Total authority and 1 count of lewd and lascivious molestation. Mr. Weeks, there is probable cause for the 3 charges. You have some criminal history, but the seriousness of the allegations against you is what's going to get you a pretty significant bond, just because it's very serious charges you've been accused of. According to the complaint, there is some type of DNA evidence that supports the state's allegations. I'm going to listen to the attorneys, and then I'm going to address your bond status. Mr. McDaniel, anything on behalf of Mr. Weeks?
No, Your Honor.
Mr. Mitchell?
Given the significance and the severity of the charges, we would request a high bond, and also, in addition to no contact with the victim, no unsupervised contact with any minors.
I believe that let me double check. I think the information's already been filed in this case.
Yes.
And the warrant says first degree felony, but I think these are actually first degree felonies punishable by life. So let me see if the information clarifies that.
Yeah, the sexual battery with the victim under 18 years of age, both of those are first degree felonies, and the L&L molestation is listed as a second degree.
But is it a first degree punishable by life? That's my question.
I think
Is it a PPL, or is it a first degree punishable by 30, which is normal? It's not going to really make a difference for bond purposes for my normal, but I'm curious. Yeah, the information filed by the state says those are life felonies, those first 2. So, Mr. Weeks, let me ask about the no contact with minors that the state's requesting. Do you have any minor children of your own or grandchildren, sir?
Not at the moment, not that's living near anything.
Okay. Mr. Weeks, what I'm going to do is I'm going to set you a bond of $50,000 each on the 2 sexual batteries, $25,000 on lewd and lascivious charge. So your total bond is $125,000 cash or surety. You have a condition of no contact at all with the alleged victim and no unsupervised contact with minors. And by supervised, that means someone who has care, custody, or control of the minor and is aware of your pending charges. So at this point, you're accused of very serious charges. I would suggest you not talk to anybody at the jail other than a lawyer about what you've been accused of. You'll get a chance to use the phone in a few minutes, Mr. Weeks, just a few minutes to try to post that bond. Whether you go through a bondsman or not is entirely up to you. If you're not able to post the bond, the public defender's office will be in contact with you at the jail, Mr. Weeks. The other thing we're going to do is I'm going to ask the jail to give you a notice for your court date in felony court, which should be March the 3rd at 8:30 will be your arraignment. Mr. Weeks, do you have any questions?
No, sir.
Have a good day, sir. We have Robert Summits.
Probation. I was going to say.
Mr. Summits, good morning. Mr. Summits, you're here for first appearance accused of 8 counts of petty theft, and 1 count of felony scheme to defraud. Mr. Somnitz, there is probable cause for these charges, sir. I have read the complaint. I've also looked at your criminal history. I realize that you're on probation for petty theft, but I also am aware of the timeline that that charge happened after these charges allegedly occurred. And that charge essentially is what led to these further investigation and review of videos. And those video reviews is what eventually led to these new charges. So this does not violate your probation because this happened before you even on probation, allegedly. Regarding your criminal history, it's not horrible. I think I saw a couple of old worthless checks from the 90s, perhaps. A 1999 grand theft in Washington County, which would be 25 years ago. So your criminal history is not bad. It's not great, but it's not perfect, but it's not bad. Let me see what the attorneys have, and then we'll go for address bond or release status. Mr. McDaniel, anything?
Your Honor, we just asked for, some kind of reasonable bond or reasonable cash bond. I mean, these petty thefts are, I think, all less than $100. They're all small amounts, and his criminal history and stuff. And he's on probation, and he's reporting for probation like he's supposed to, and doing what he's supposed to. So we just asked for some kind of.
Is his status? Is he up to date on everything?
Thank you, Mr. Mitchell.
We don't object to a cash bond. I was just asking Mr. Goodson if he's up to date on everything with county probation.
I am, Your Honor. I'm supposed to get off on the 2nd. It's all paid off and the classes are all done.
Okay. Yeah, no objection to a cash bond.
According to Mr. Ham, he was supposed to be able to get off early on March the 2nd.
So, Mr. McDaniel, I don't think you were in the loop because it wasn't about specific cases, but there's an issue with this exact situation where, depending on what law enforcement officer is doing it, some law enforcement officers are doing it the way Mr. Somnitz was done, which is 1 felony and multiple misdemeanors. The majority of law enforcement officers are charging just a bunch of misdemeanors. And as you know, because you represent a bunch of them, they come to court and Mr. Mitchell's got a policy in effect that he's very consistent with that's effective. He collects restitution in one case and puts them on PTI or probation in that case and dismisses the others. So I expressed to the state attorney's office my concern about the inconsistency in the way these cases were handled. And I think they've kind of got an internal policy now to try to prevent that from happening. But this is a perfect example of Mr. Somnitz being treated differently than someone with the same or similar criminal history. The only difference is what officer does the complaint. And I think there's probable cause for these charges, but you and I see these every month that are handled in misdemeanor court. So that's obviously a factor that I'm very concerned about being consistent. So for that reason, what I'm going to do is I'm going to treat it like we do with the cases in misdemeanor court. And if you want to, I'm not going to offer you a conditional release because of the number of cases, but I will set you a cash bond on the felony. I'll set a $500 cash bond and I'll give an ROR on the other 8 cases. So you've got a total cash bond of $500, an ROR on all the misdemeanor cases. If you post a cash bond, you'll be released immediately. Whether this will stay in felony court, Mr. Somnitz, or not, I have no idea. That's a call to be made by the state attorney's office. But I think they're kind of getting their prosecutors on the same page to either have one prosecutor look at all these cases. That way they know they're being treated the same, regardless of how law enforcement treats them, at least the prosecutor can treat them the same. Or if it's multiple prosecutors involved, they can have a similar policy. But right now you're going to felony court on March the 3rd at 8:30, unless the state decides to transfer your case to misdemeanor court. You've got a $500 cash bond. Your condition of no contact with Walmart is being renewed. So even if you get off probation in the other case, you've got a no contact condition in this bond. So that no contact condition will extend if this case is pending or these cases are pending, even if you get off probation. Mr. Somnitz, any questions about any of that? No contact with any Walmart, yes. Mr. McDaniel, have I missed anything? I know it's kind of complicated.
No, I got it all. And I'm just going to say that, are they going through the prosecutors now, or are they still sending them straight to the judges? I mean,
the state attorney's office asked to not be, they're not asking to be involved in warrant reviews unless the officer wants them to be involved. That started probably the October, sometime around there. And so most officers just rather get it done quickly. So they send it straight to the judge now, like they do in Bay County. They will review it. The state will review it if the officer wants it reviewed. I think that's correct, right, Mr. Mitchell? But in these cases, what I've started doing is if they have no criminal history, I make them take it to the state attorney's office because they're just so inconsistent. Similarly situated defendants are not being treated similarly. I think it's just an oversight caused by the state attorney's office not being involved. For years, they reviewed the warrants and they kind of have their own standards and everything was pretty consistent. That's not happened since about October.
That's the way we always do it. I think that's the best way to do it is if you want consistency, is let the prosecutor review these things before they're filed.
Yeah.
But also, Jay,
So-
I was gonna let you know that he's on probation. If you're wanting to do something to extend the probation, I'm sure he's open for it and restitution. If that's, I'm not saying this, I'm just saying if y'all want to think about it, y'all, I mean, I'm not sure what all the total is, but if you want to do something, I'm sure he's open to it.
I'll talk to the felony attorney and see what they think about it.
And that's a question I have is these are third degree felonies. I know you're doing some felony cases. Are you just doing VOPs or are you doing some new cases too?
Just doing VOPs for right now and the random ones that get thrown into drug court also.
So this would be whose case, Mr. Guild or Ms. Harris?
Probably Miss Harris's.
Okay. All right. Any questions at all, Mr. Somnitz? All right, sir. You'll get to use the phone in a few minutes, sir, to post the bond, okay? Next case is Brandon. You want to take Brandon Bullard last? Is that what your text says?
Yes, sir. Well, I guess he's in here. Come on here, Brandon.
Brandon Bullard is next. Mr. Bullard, come on up. Mr. Bullard, good morning. You're here for first appearance, charged with one count of trespass after warning. You're also accused of one count of resisting an officer without violence. Mr. Bullard, I have read the complaint. There is criminal history. There is probable cause. And I looked at your criminal history and I'm aware that you just were sentenced to 60 days in jail in January last month in Washington County. So I'm aware of all of that. I want to see if the attorneys have any additional, information they want to make me aware of. So let your attorney speak on your behalf and then we'll address your bond status. Mr. McDaniel.
No, I don't have anything.
I was robbed by 3 city police officers that put me in there, the same ones that robbed $335 out my wallet. I just grabbed them.
Mr. Mitchell, anything on behalf of the state?
Nothing at this moment.
Okay. So Mr. Bullard, I think you're entitled to a bond because the Washington County case was a jail sentence, not a probation sentence. If it was probation sentence, you wouldn't be entitled to a bond, but you are, it appears. So I'm going to set your bond at $3,500 on each count. Your total bond today is $7,000 cash or surety. You have a condition of no contact at all with the property that you were accused of being at unlawfully or allegedly refused to leave. So you cannot go back to that property at all. You cannot go back to that property at all. Questions?
I understand that, but she asked me to come there to babysit our son, and I've been watching him for the last 4 days.
That's not why you're arrested. The reason you're arrested is the complaint says the officers told you to leave and you refused to leave. So even if you were invited over there, once you're lawfully ordered to leave, unless you have significant ties to the place, such as living there, you have to leave. So you're not being charged because of being there when they got there. You're being charged because of what allegedly happened afterwards. Don't talk about what you're charged with. I don't want you to say anything to hurt you, but I do want you to understand it has nothing to do with whether you're invited over there. That's not what you're accused of. You have any other questions?
Yes, sir, I understand, but I was not resisting or nothing. He just really didn't give me a chance to grab my stuff and leave. So he told me on the ground, with all due respect.
Any questions?
No, sir.
Have a good day, sir. He does need to be given a notice. It's misdemeanor court, so it would be the March 2nd at 9 a.m. Corporal's out of the room. Is there somebody in the room that got that?
We're writing it down. We got it.
Yeah, sorry, got it. Thank you. We have Belina Pullman next. Ms. Pullman, good morning. Ms. Pullman, you're here for 2 charges, ma'am. You're accused of 1 count of uttering a forced instrument or a forced bill. Not a forced bill is what you're accused of, ma'am. And then you also have a hold out of Washington County. The Washington County hold looks like it's a violation of probation warrant, ma'am. It has no bond on it. The Jackson County charge, you're entitled to a bond. I'm about to set you one. But let me see if the attorneys have any additional information on that bond I need to be aware of. Mr. McDaniel, anything?
Your Honor, I talked to Ms. Pullman. She maybe is asking for an option for a cash bond or a surety bond if the court's inclined. I don't know if there's restitution owed or I'm not really sure.
Mr. Mitchell?
If she wants a cash bond, we don't object.
There's allegedly restitution owed. It's only about $100. The problem is that she's on state probation when this charge allegedly occurred. The basis for the violation of probation is not just this charge. She allegedly was instructed to remain in the office by the probation officer and she allegedly left the office. So there's two different ways you have supposedly violated your probation. It's more than just this new charge, but I don't have a problem with a cash bond. There is restitution that's being sought. Your cash bond, Ms. Pullman, in the Jackson County case is $500 cash. Ma'am, you've got no bond in Washington County. So just be aware, if you post a cash bond, you will go from our jail to theirs. You will not be released, but you will get the case over there moving. Do you have any questions, ma'am?
No, sir. No, sir.
All right, ma'am. Wish you the best.
March 3rd.
She does need to give a notice, please, for March 3rd at 8:30. Thank you. The next case we have is James Douglas. Douglas, I see you signing that. I'm going to assume that was a waiver of extradition for Houston County, Alabama. Is that what you just signed?
Yes, sir.
Do you have any questions about that extradition waiver?
No, sir.
So I know that Mr. McDaniel's already spoken to you. They have 30 days to pick you up. We review the cases at 15 days. If you're still here in 15 days, you'll come back to first appearance and we'll see what the transport status is. I don't think I've ever had that happen with Houston County. They've always picked people up within a week or less. But if you are still here, we'll see you and see what's going on. But they have 30 days to pick you up. We'll see you in 15 if you're still here. Any questions?
No, sir.
All right, sir. Wish you the best.
Thank you.
Yes, sir. Michael Hamilton. Hamilton, good morning. You're here because you've been accused of one count of felony battery and one count of uttering a forced instrument. These are two different alleged offense dates. There is probable cause for both charges. There's also a significant criminal history that you've got here. Mr. Hamilton, I'm going to listen to the two attorneys and then I'm going to set your bond. Mr. McDaniel, anything on behalf of Mr. Hamilton?
No, Your Honor.
How's it felony? That's what I'm wondering. Was it felony?
It's a felony based upon you having a prior conviction for battery. That's what they're accusing you of. Your second or subsequent battery in Florida is a felony. Mr. Mitchell, anything from the state?
No, from the state, Your Honor.
Mr. Hamilton, I'm going to set your bond at $7,500 each on these two third-degree felonies that you're accused of. That makes your total bond $15,000 cash or surety. You've got a condition of no contact with the alleged victims. One of them is, I think, McCoy's Outdoors. The other one is the female. No contact with either of those individuals. And you have the right to use the phone to try to post the bond. Mr. Hamilton, the jail's going to give you a notice for your court date, which will be March the 3rd at 8:30, and you'll get to use the phone in a few minutes. Do you have any questions?
No, sir.
Have a good day, sir. We have Eustacia Allen next. Miss Allen, good morning. You're here for first appearance. I think the jail sheet is wrong, Corporal. I'm gonna need y'all to take a look at that. On Miss Allen, the complaint appears to show 2 counts of possession of controlled substance without a prescription, but the jail sheet says 1. Before I set 2 bonds, I need to make sure that's right, Corporal.
We're double checking right now.
Thank you.
Yes, sir. 2 counts. Yes, sir.
So, Miss Allen, you're accused of possession of 2 different controlled substances. I think they were in a single, supposedly in the same container, but there were 2 different controlled substances that were identified in there based upon the lab test. So you have 2 charges, but it's a single container, so it's a little confusing. They're accusing you of 2 different felony charges, Miss Allen. There is probable cause. I've also looked at your bond. I mean, I've also looked at your criminal history, so it's pretty lengthy. And let me see. Let me take another look at I can't remember if this was a pill substance or if it was a powder substance. Let's see. Yeah, it was a powdery substance that you were accused of possessing. Mr. McDaniel, anything on behalf of Miss Allen?
No, Your Honor. We just asked for a reasonable bond.
Thank you. Mr. Mitchell, anything?
We're fine with a reasonable bond, but we request you also have random UAs as a condition.
Thank you. Miss Allen, I'm going to set your bond at $5,000 each on these 2 third-degree felonies, ma'am. Your total bond is therefore $10,000. Miss Allen, that's cash or surety. That means you don't have to come up with all the money. You can go through a bondsman. That's what a surety bond is. Your bond does have a condition of random urinalysis. So be aware of that term if you do post bond. Miss Allen, do you have any questions? No questions?
Not at the moment.
All right. Have a good day, ma'am. You do have to be given a notice. I apologize. Thank you, Dawn. Please give Miss Allen a notice for her court date, which should be March the 3rd at 8:30. And the last case, I think what may be the last case is Tracy Gaines. Ms. Gaines, good morning, ma'am. You're here once again for the charge of driving under the influence. Ms. Gaines, there is probable cause in the complaint, ma'am. And I've looked at your criminal history. I see 2 recent DUI charges within the last 2 years or so, one of which Mr. McDaniels advised me was dismissed, the other of which you were convicted of here in Jackson County. And that was just right about 2 years ago. So those obviously are factors for me to consider. And Ms. Gaines, let me see if Mr. McDaniel or Mr. Mitchell have any additional information before I set your bond. Mr. McDaniel?
We just asked for some kind of reasonable release option. She has strong local ties, family members, owns property, works in the area, and we just asked the court to consider some kind of release option.
Thank you. Mr. Mitchell?
Whatever the court deems fit as a release option, we just request that she have a condition of no possession or consumption of alcohol.
Okay. Ms. Gaines, I failed to mention that there was allegedly an accident in this case. So that means you've been charged with 3 DUIs in the last 2.5 years. This one resulting in an accident. That's causing me concern, not only about your judgment, but about your danger to the public, the general public. Your bond's $5,000 cash or surety. You have a condition not to drive a motor vehicle at all. And you have a condition not to possess or consume alcoholic beverages. Now, let me explain the motor vehicle condition. If you're able to get some type of temporary or work permit, then you come back to court, and I will certainly consider modifying that for work purposes. But for the time being, based upon the number of DUIs you've been charged with, your bond has a condition not to drive a motor vehicle. We got to figure out what's going on and stop this. And that's the only way I know to do to protect the public is keep you off the roadways. If you get a work permit from DHS&B, I certainly will consider it. I'll give the state a chance to have input. But for the time being, you cannot drive a motor vehicle. Ms. Gaines, do you have any questions, ma'am?
Judge, did they put on the ticket or something? They took her license, or, I mean, I know she qualified and did everything.
I don't know that they turned in the citation here. Let's see. And it's on the back of the ticket where you have to see it. And let's see. I don't know that it says whether or not they have the right to give you that ticket as a license for 10 days is what Mr. McDaniel is referring to, ma'am. I can't tell from the paperwork I've got. What I'm telling you is now that you've been involved in the wreck and there's allegedly had a bottle of vodka in your pants when it happened, half bottle, I'm telling you, you can't drive. That's a part of your bond. If you get a work permit, I will certainly reconsider it. So still go through the process, try to get a work permit if you can. But in the meantime, you're not driving. Anything else, Mr. McDaniel?
Just clarify that, I mean, if she has a license, she can drive though. I guess, or you said a work permit, but I know
she has a license. I don't know that she has a license. She cannot drive as a condition of her bond based upon her being in a wreck and having 3 DUIs in 2.5 years. That's it.
That's all right. That's all right.
You have 3 DUIs arrests. Now, one of them, Mr. McDaniel says, was dismissed in Alabama. That may be. You have 3 DUIs arrests in about 2.5 years. You cannot drive. I'm not going to modify that. You can't.
I gotta go to work tonight.
You're not driving. You go to work if you want, but you better not drive. Okay? She needs to be given notice for her court date. Her court date will be March the 2nd at 9 a.m.
All right, man.
Have a good day, ma'am.
Just, I'm not trying to, I mean, a lot of these cases, when they cooperate and stuff, they don't necessarily suspend their license. So that's why I was saying, because you said if she gets a hardship, but if her license, I guess it wouldn't be a hardship if she has license, if they don't suspend them. Stacy can probably tell me more about it.
She may be able to register for DUI school, but I don't know on a second DUI if that law lets you do that. Mr. Goodson, the question is, if she registers for DUI school, can she apply for a work permit on a second DUI?
My understanding of the law is no, because she's had, this will be, so the officer marked on the ticket, there's a box here that says eligible permit. He put no. I don't think the officer has the authority to give a 10-day permit if they've had a previous DUI conviction. And my understanding of the law, because she had a previous DUI, she is not entitled to apply for a business permit.
I think he's right because it's a second, Mr. McDaniel.
That's fine. I just wasn't for sure if there had to be a conviction since she cooperated. I'm not thinking straight. But yeah, that's fine.
He did not give her the 10-day permit. I don't think he can because of a previous DUI.
Yeah, understand.
We have one young lady that's in the courtroom. Ma'am, are you here for a first appearance case? I failed to ask that earlier. Are you here for a first appearance case? Okay, I'm sorry, I didn't tell Miss Allen you were here. I didn't even realize you were here on her behalf. Do you want her to know that you were here? Did you see her case? Were you in the courtroom when she went? Okay, so you got to see it. What's your relationship so we can tell her that you're here? Okay, can y'all let Miss Allen know that her mother did come in the courtroom? So you heard the bond that was set for her, ma'am? It's $10,000 cash or surety because of her history. And she's charged with 2 counts of possession of controlled substance without a prescription, 2 different controlled substances. Any questions, ma'am? I can't hear you. It was in a cup in her hand. And then she put it back in the vehicle, according to the complaint, and I wasn't there. And when she got out, she asked if she could get out and go to the restroom. They said, no, you got to wait here. She supposedly puts the cup back inside the vehicle, and they take the cup and look in it. There's powder in there. They analyze the powder, and it's 2 different controlled substances. And as you know, she's got a lengthy criminal history. So that's what she's accused of. Yes, ma'am. All right, so Mr. McDaniel, that's everything I had on my list. I did want to talk to you, Mr.
The one thing I continue to like about Judge Mercer is the amount of attention that he puts into family members who are in the courtroom. There's no other judge that does it quite like him, making sure that the defendants know that the family member's there, making sure that the family members' questions are answered. He actually takes the time. Nobody does it quite like that, and I've always really appreciated that. A whole slew of courts are coming online right now, so I'm going to sort through all of that. Ashley, if you could help me out, I'm pretty sure there was something with Judge Wolf that I was supposed to be looking for today, and he has started his feed, though he's not on the bench yet, so if you could update me on that. But as I sort through these other feeds, let's go back to Judge Simpson for a little bit.
Senior Assistant Public Defender representing Ms. Pataski. Ms. Pataski, would you please state your name for the record?
Margaret Pataski.
Your Honor, I did submit yesterday, late a plea form for
Yes, it was late,
yes, I'm acknowledging.
but I don't,
A plea form for no contest plea for Ms. Pataski. And Ms. Pataski, we went over your rights to a trial, and
I don't have the plea form, so I have the police report, but I don't.
It was not signed.
That's why. With permission or otherwise, it was not signed. So it wasn't.
So I would like to apologize. Many of these procedures were not procedures a year and a half ago when I was last here. And so I am catching up on the procedures. So I
understand that, Ms. Gaines.
And
I blame that on everybody else that's around you that should have explained it to you.
So if we could pass for a short moment, I know this is very important to Ms. Pataski. Her outdate has passed.
I'll pass.
Thank you, and I will get that stuff.
Juan Crawford. Pardon?
Good morning, Judge. My name is Alan Cooper for Juwan Crawford.
Your Honor, good morning. For the record, Mark Burke, P54935 with the Attorney General's Office appearing for the people.
Name, sir.
Juwan Crawford.
Your Honor, it is our ultimate intent to try to waive this exam, although I haven't actually had an opportunity to speak with my client about it. I was wondering if perhaps we could maybe address the issue of bond so I could have a better chance to meet with him and then have a better conversation with the prosecutor.
Well, that may not, I mean, you can argue it, but I think his bond is set pursuant to statute in this case at 25% of what he owes. So
yeah, I understand that, Judge. I think that sometimes that it's overlooked that the statute does require a good cause exception. I understand that it provides for.
Oh, no, it's not overlooked. I look at that every time.
And the issue
So
is,
if you want to make your argument, go ahead and make your argument, counsel.
Okay, great. Well, the thing is, my client does have a job that's waiting for him on for February 17th. So obviously, the whole point of this case, with the child support case, is to try to get money and get payments to try to get his arrears paid down. So that's a real truck in Ann Arbor. I actually do have a copy of the letter showing his job offer. So he's supposed to start there on February 17th. So our hope is to get at least some kind of bond, so that way he can start working. So that way, obviously, at some point, we're going to negotiate this case, and it's going to involve payment of some money. So he can't do that if he's not working. So I don't want him to miss this opportunity for employment when it's right there waiting for him. So he does have the family in the community. His mother's supposed to be there at court. I just got off the phone with her. She's at the courthouse. He's got substantial family in the area. So I would ask for a personal bond. He takes care of his father, who's an amputee.
I'm sure, counsel, that he was working at some point before his child support got to over $25,000, right?
He was unemployed for a substantial period of time, and he tried to file some motions to modify his child support over the last year or two, but he tried to do it improper. So of course he didn't get a proper hearing date. So our intent is to backdate that, and we're going to go through the civil court as well. It's not going to completely reduce all the arrears, but it's going to have some reduction if we can go retroactive back to the date when he first filed those, because he was unemployed for a significant period of time. But the problem that I have is that he's got this job waiting for him. I don't want to miss this. I don't want him to miss this opportunity, especially when he's going to have to end up paying something towards some arrears.
Any response from the people?
Your Honor, thank you. The only thing I would indicate is the court is certainly well aware of the statute. It's 750.165. It does require 25% cash bond in the amount of the arrearage. Judge, the arrearage currently, as of 2 days ago, is north of $32,000. The bond that I see, that I believe is that's ordered is $63.95. I mean, quite frankly, it's probably low compared based on what the arrearage is today. But the other thing also is I appreciate counsel's argument that he wants to work and he wants to start paying. But the reality, Judge, is the defendant has an ongoing obligation of $555 a month right now. He's paid a total of $1,500 in the last year. That's it. So, I mean, and I don't think he's been in custody that long. So, in any event, I mean, I'll leave it to the court's discretion, but a PR bond is definitely not within the statute. So that's a good position.
I think the statute specifically does provide for a good cause exception. I think the fact that this case is a nonviolent offense, it's financially.
I don't find good cause, counsel. He's now, the bond actually is low of the 25% because we set it based upon 25% of what's in the complaint. From the time of the complaint till now, he obviously hasn't paid because that amount has grown by almost $7,000. And so there hasn't been anything paid. I am not in this and don't find, based upon the argument, a good cause exception to the 25%. I won't raise it based upon the number given by the state today, but I'm going to leave it where it is, which means it's going to be lower than the 25%, but something's got to be paid on this. So motion for bond reduction is denied.
All right.
As to this case, what do you want me to do with it?
Well, personally, I'd like to waive the exam. So we're fine waiving the exam.
Well, does your client want to waive, or does he understand what that is?
I haven't had a chance to speak to him yet about that, Your Honor.
Probable cause conference will be adjourned 1 week out. February 19th, 2026, 9 a.m.
Thank you.
Sir, he'll talk to you and then we can figure out where we're going. Understood, sir?
Yes, sir.
Thank you.
Your Honor, thank you.
Bond continued. Thank you.
Mr. Cooper, thank you. If you want to talk, give me a call anytime, okay?
Court calls the case, People versus Tyler Oliveira.
Assistant Public Defender Ben Dunworth on behalf of Mr. Oliveira, who should be appearing on Zoom from MDOC.
But we got to get him unmuted. Oh, he is. Mr. Oliveira, could you state your name, please?
Tyler Oliveira, can you hear me?
Yes, sir, we can. Thank you.
Okay.
What are we doing?
Your Honor, this is Mr. Oliveira's first court appearance. I have not yet been approved by MDOC to meet with him, but I did request so on Monday. Defense would have to ask for 2 weeks to meet with our client.
Probable cause conference is the 26th going to be enough for that to happen? Or am I going to get here and adjourn again?
They don't turn the form in?
Pardon?
Do not turn the form?
No, is that going to be enough time, the 22 weeks? Is that going to be enough time for you to get approved, meet with your client and do something productive? Or do you need an additional week?
We'll take 3. Thank you, Your Honor.
Probable cause conference, March 5th, 2026, 9 a.m.
Thank you.
Bond continued.
So real quick, Great Granny was asking for Ellie. This is Ellie right now. She's a little indisposed at the moment. It's sleepy time. She absolutely collapsed yesterday. She slept most of the day, so she's just kind of been out of it. But she's down at my feet right now. I still have to install an Ellie cam down there, so we're gonna work on that. But at some point she'll wake up during the stream and you can say hi to her. Anyways, back to Judge.
Attorney Feaster, Assistant Public Defender on behalf of Brian Laster. Mr. Laster, how are you?
I'm fine, how are you?
Good. Please state your name for the record.
Brian Ian Laster.
Thank you, Judge. I did reach out to the prosecutor on this case. We are working on trying to get a resolution to this file. Today, we have not yet resolved it. Hopefully, we can come back in the near future and get this matter resolved. We asking for a brief adjournment, Your Honor.
That's fine. Do you realize he has another case?
I did not, Your Honor.
Been rather sort of a cluster getting it here because we're not sure what happened, but we have a duplicate.
Oh.
It's a charge of larceny in a building, the 4-year felony.
Okay.
I'll give you the case number. It's 26F5 5030.
Okay. Thank you so much, Judge. I will include that in my
Pardon?
I will include that in my discussions with the prosecutor.
I was told I was less than $200 in the charge I'm here for now. I'm not aware of what the charge is here for today.
Okay.
I was adjourned, I was
Okay.
and the $200 from a
Let's not
mill.
talk about the
Well,
facts of the case.
hold on, Mr. Laster.
And this charges, this stipulation charges are.
Mr. Laster, I'm going to ask you to be quiet. I don't want you to say anything about the case at this point. And certainly counsel doesn't know about that. I'm just gonna, why don't we just go through the arraignment on this? Mr. Laster, the complaint alleges that on or about November 8th, 2025, location of 210 South First Street in the city of Ann Arbor, Washtenaw County, state of Michigan, that you did commit the offense of larceny in a building. Specifically, it indicates that you did commit the crime of larceny in a bar or public house by stealing from the cash register drawer and stealing from the cash register drawer cash, and then 3 bottles of High Noon seltzer, contrary to Michigan statute. I'm not asking whether or not you did it or not, but do you understand what you were charged with?
Understand?
Excuse me. Yes, I understand.
All right.
And
that's a felony punishment by.
It's authority to.
Pardon?
The guy across the street.
Let's not talk details of the case today, because anything you say is against you.
All right.
So you understand what you're charged with,
Yes,
sir?
I do.
You understand that that's a felony punishable by up to 4 years incarceration
Yes, I
and
do.
a $5,000 fine plus court costs.
Yes, I do.
Do you wish to be represented by an attorney?
Yes.
Mr. Feaster, take over, please.
Thank you, Judge. Torrio Feaster, Assistant Public Defender on behalf of Mr. Lester on the new file. Laster on the new file. Your Honor, we would waive any form of additional reading and we would stand mute, Your Honor.
Defendant, every way form of reading standing mute, court will enter not guilty plea. I will set probable cause in this case. How much time did you need on the other matters?
Just a couple of weeks, Judge. We had a fairly decent offer.
All right.
Maybe we can incorporate.
That's fine. I'll set a probable cause conference for February 26, 2026, 9 a.m. As to his bond in this case,
Your Honor, I believe he's had to bond in his other cases.
Pardon?
I believe he had to bond in his cases he's in for right now. I'd ask for a low bond on this one as well. Getting credit on everything.
Well, what's he in on? I have 1,000 cash or surety on one of them, and one of them also he has a personal recognizance bond.
Yes, that sounds right, Your Honor.
Pardon?
That sounds accurate.
What I'll do in this case, I'll set his bond. He's got other cases, so I can't do. I'll set it at 5,000, 10% at this point. Other standard conditions, including no assaultive behavior or possession of any weapons. You're not to possess any alcohol, recreational marijuana, or any illegal drug. I will also indicate that he is not to enter 210 South First Street in the city of Ann Arbor.
Thank you very much, Judge.
Thank you.
Thank you, Judge.
Welcome. Court does call the case of the people versus Margaret Petoskey. Well, where's Miss Gaines? If I,
Oh, my God.
Ms. Gaines?
pardon? Well, yes, because she's the one. Pass it briefly. Court does call the case of the people versus Jayla Allen. Jayla Allen.
Good morning, I'm Charlotte Stefan on behalf of Ms. Allen.
Morning, your name?
Jayla Allen.
Jayla.
It's okay.
All right.
Your Honor, I was just appointed last night to this, so I'm requesting an adjournment. Would 4 weeks be okay with the court?
Probably not, but you need 4 weeks.
Yes, Your Honor.
Hearing no objection, probable cause conference will be adjourned to March 12th, 2026, 9 a.m.
Thank you very
Bond in
much,
this
Your
matter
Honor.
will continue. Thank you. Court calls the case people versus Kadena Self.
People, Your Honor.
Gaines back.
Good morning. Good morning, Your Honor. Christina Saxon from the Self. Please state your name for the court. Kadena Self.
Thank you. What are we doing?
Your Honor, would like to make a bond argument and set this for a preliminary exam.
Discovery's complete.
To my knowledge.
What date are we in? People have their witnesses available to 24. Preliminary examination in person will be set February 24th, 2026, 9 a.m. before Judge Barr. As to bond.
For Ms. Self to be released on tether. Since the last time we were here, I've learned, excuse me, that the alleged victim in this case has been arrested and charged. When we were here last time, her arm was in a cast, and that was from a domestic violence event with him. They do not reside together, so I'm asking for a release with a tether. And in addition, just to show
Do you
that
think something has changed since the last time I denied bond?
I have more information about that, the fact that you only heard that there was a stabbing. From the looks of this, it actually warrants me having it looked at to make sure that he had not done that based on the angle of the marks. So, yeah, that has changed. It's a presumption that warrants more consideration. And on a side note, she wanted me to let you know she completed her GED for language arts yesterday. So she has used her time in here so far wisely.
Response?
Your Honor, I would object again. That previous case that was mentioned by Ms. Saxon was dismissed, I believe, 2 weeks ago. The facts that I brought to the court before I concerned, I also have issues about with intoxication as well. So at this point, I object.
Motion for bond reduction is denied. Bond will continue. Take a look at it again. Thank you.
It's TCF Live on a Thursday, and a special guest has showed up in the chat. Bailey, welcome back. Good to have you here. Oh, what do we got going on today? Tonight, sidebar, 8 p.m. Eastern, 5 Pacific. We're going to be discussing the Louisiana parole hearing we heard the other day with the mother and the malnourished child. So that should be a hoot. Also, last night we did In the Blind with Mike and Dan. Barb, if you do me a favor and drop a link for that. If you did not see last night's show, go check that out. It is not court related, and that's the whole point. Mike and I have two topics. We have no idea what they're going to be until we are live, and we have a lot of fun. And I thought last night's show was pretty good. So check that out if you have not already. Let's change it up a little bit. Let's go to Texas and Jefferson County. Judge Stevens.
Mr. Kimmer, have you talked to him lately? He's your lawyer, right?
Yes, sir.
Have you talked to him lately?
No, I was going to call him.
Well, when was the last time you had a chance to talk to him?
Like last time I came.
Last month?
Yes, sir.
Well, we had you last week, right?
Yes, sir.
And have you talked to him since then?
Yes, sir.
No.
Okay,
Before that, it was on January 9th. You didn't talk to him before January 9th, huh?
I
then
before.
Huh?
Yes, sir.
Then I see something on 2/4/26. See, what happened was you were supposed to be here in October, and then we reset it until January. And actually on January 9th was a date, and then we reset it to 2/4. When was the last time you talked to him? Months ago?
When I came in October.
In October? That's the last time you talked to him?
Yes, sir.
Okay. All right. Just have a seat, Cedric. Thank you. Sorry about that. Your lawyer should be speaking to you more often than that.
Yes, sir.
Stephen Dodd and Michael Reisinger. Are you Stephen Dodd?
Notify me that he will be a little late, and that's supposed to be a disposition this morning.
Stephen Dodd. Let's see if he's around.
Dodd. Stephen Dodd. Stephen Dodd.
No response to that name being called in the hall. No response to the name Stephen Lynn Dodd being called here in the courtroom. The defendant has failed to appear in cause number 24 CR 699. What is his bond, please?
$7,500.
$7,500 is the bond. His bond is revoked. Warrant is issued for his arrest or failure to appear. It is doubled to $15,000 plus the defendant must have a GPS device on him so we know where he is when he's not in court where he's supposed to be. and we will alert his lawyer that his client has failed to appear.
Stop the help at all.
All right, well, we deal with the sound of silence out of Stevens Court. Let's go back up to Judge Dad, see what's going on.
On a civil infraction charge of no proof of insurance, that's 0 points. Do you understand that? Did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights. We're not going to have a trial of them. You understand that? All right, you still wish to waive your right to a lawyer? Enter a not guilty plea, $100 personal bond. You cannot leave the state without consent. You can't violate a law. You must appear in the court as directed. Why weren't you here on January 29th?
I thought that I court on Friday. I was on the 30th.
Did you show up on the 30th?
No, I called up, you
What'd you call up here on what day?
called on the 30th.
For what? Why'd you call if you thought you had court? Why don't you just come up here?
I couldn't get the day off work. I was going to try to study. Told me that I had court on the 29th.
Go down, talk to the prosecutor, come back in. Have a seat right out in the hallway and they'll set you up. Good luck. Stevens Disposal, 260-647-612. Good morning, Mr. Osmond.
Good morning, Your Honor. Jeff Osmond on behalf of Stevens Disposal.
All right, so this could be a plea to overweight violation, agreed upon fines and costs of $400. And then you're going to also have the defective equipment will be dismissed, true?
Yes, sir.
You're authorized to enter that plea on behalf of the company?
Yes, Your Honor.
So the charge overweight is responsible or not responsible?
Responsible.
Plea is accepted, fines cost $400, pay by March 12th. Defective equipment is dismissed. Have a good day, Mr. Osmond. Take care.
You too. You too.
Giles, Daniel Curtis Giles, 25T6460538. Do I have any of the victims here? I want to make sure that I don't have any of the victims here, and that includes Nicholas Cady. Is Nicholas Cady here? And if he is or isn't, is Benjamin Forrest here? Benjamin Forrest, Nicholas Cady. Mr. Gamber, good morning, your appearance.
Good morning, Your Honor. Tim Gamber, on behalf of Mr. Giles, it's also President Flag, state your name, Daniel Giles.
Give me 1 second here. All right, so the defendant had previously pled disorderly conduct, to disorderly conduct.
One count, I think, but
And then the other two were dismissed. So I have the A file. The victims were notified. Again, are either one of those people on Zoom? Heather?
No, Judge.
Okay, so we'll go ahead and proceed. Have you had a chance to review the report with your client? And are there any material additions, corrections, or deletions?
yes, Your Honor, we have a couple. We did have a chance to review it this morning. Under the current doctor of care, he is seeing Dr. McNally, which is MAKHMI, and that's for his knee. Under the health section, it indicated good. He is still rehabbing a torn ACL. Shall I continue?
You don't need to talk about his medical.
I'm just talking about like accuracy, Judge.
Okay, good enough, good enough. Whatever you want. I mean, I'll modify.
I'd just like to make the record clear.
That's fine. I'll modify the report in that aspect.
The third thing on his employment status indicated that he hadn't worked since August 1st, and that should read October 1st, which is the date of the alleged incident.
A fourth issue that we had, Judge, was that, the probation department had recommended a site evaluation or basically, to be evaluated, and attend a mental health treatment as recommended by a approved agency. Your Honor, this is how we got here. He went into the hospital, he was anxious, he had some issues, he wanted to have his rest. Came out of a psych hookup a week later with a torn ACL. So that's how we got here. In my.
Say that again?
He went to the hospital.
I know. And that's where he told him he had suicidal ideations, right?
Well,
And then he attacked the two.
That's the allegations that are meant,
Well, wait a second. Be careful with me because your client pled, you keep saying alleged. There's no alleged anymore. He pled no contest to disorderly conduct. I relied on the police report to establish a factual basis. It said he went over to Corwell. They were going to treat him. And he had suicidal ideations and started punching a couple of the attendants, the nurses, right?
That was the allegation.
Well, there's no allegation. Wait a minute, slow down. Stop saying allegation. This is a no contest plea.
That's accurately reflective of it.
Okay, so you allowed, you said you stipulate, when you do a no contest plea, you stipulated to the use by the court of the police report. And that's what the police report says. I mean, if he's, well, I'm just telling you, if you're going to continue to say allegations, maybe he shouldn't have pled to anything if he's denying any of this. I'm only pointing out why they recommended that.
Perhaps, I'll move along on that one.
Okay, go ahead.
And then just as far as the fines, Your Honor, it is clear, taking into consideration the fact that he has not worked and has not been able to since October 1st. And that's all the corrections or additions that we have on the pre-sentence investigation as well.
All right, anything else?
Nothing at this time.
Sir, is there anything you'd like to say? I mean, your conduct was out of hand here. It was out of hand. And the prosecutor was very generous, and that's their business, and I'm not going to get involved in it, but you start assaulting people, and I realize, I'm just saying, I realized the plea was to disorderly conduct, but I relied on the police report, and all the police reports brought with is you punching these guys, and you telling them you had suicidal ideations. I'm going to go ahead and place you on probation for 12 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. You're to undergo a psychological evaluation and treatment if recommended. You're not to have any contact with the victims, Nicholas Cady and or Benjamin Forrest. You're to pay fines in the amount of $200, costs in the amount of $150, $75 victims' rights fee, $50 justice assessment. So fines and costs are $475, screening fees $60 for $535, probation fees are $240 for $775. So again, no contact with the victims. Psychological evaluation and treatment if recommended. I want to order 5 days jail credit, 1 serve 4, and I'll let you serve those as follows. You're going to serve, and I realize you have this issue going on with your feet or with your ACL. 3 days court work program, 1 day community service, $105 in court work program fees, and I'll make sure that defendant not to be scheduled for court work program, until at least August. And if you have a problem that prohibits you from still doing it in August, you bring your doctor's note and I'll revisit that. 1-day community service, I'll give you until May the 1st to complete that. That, you can do that at any sedentary place. And the total here is $880. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer. Any questions? Mr. Gamber, anything else?
Nothing, Your Honor.
So when can he pay these? Do you want me to set him up on a payment plan?
Yes, please. I mean, until he gets a job and is able to get some income, he's gonna need a payment, if that's possible.
Yeah, I'll do $200 a month, and we'll start that beginning on July the 1st. How's that?
July 1?
July 1. And if he doesn't have the money to pay at any point, all he has to do is call the court. We'll go on Zoom. I'll give him an extension. You'll meet with probation here. Anything else?
Nothing at this time, Your Honor.
Sure, anything else? Any questions? Best of luck to you. Luke Anthony Durant. Luke Anthony Durant, you will meet with probation.
Let's change it up. Let's go back to Judge Stevens, new contestant approaching.
She's responsible.
She got sick. I know she wrote it to you on a text because I was there. She got sick and she was telling you that she can't really hear from that, so you have to talk to her about when you have to write to her. So she can get it. So
How long?
She has a doctor excuse for that.
she went to the ER twice and they told her, and now she's
She has something in writing saying about confirming the condition or not. A medical practitioner.
yeah, the hospital and Dr. Krishy.
Do you have the paperwork?
Yeah, but not on me.
You're in court. Why didn't you bring the paperwork?
I can't ask you.
That's okay. I'm not a problem with it. I don't have a problem with it. Y'all just need to communicate with her. You know, if y'all need to go in another.
On her behalf to speak.
Yes. Yeah, y'all talk, but you don't need to do it here. You want to do it in another room?
Yeah, that would be great.
Okay. We're still waiting on a juror. Okay, you can go in the jury room for a few minutes because when the other juror shows up, they got to go back and deliver.
I need to sign up Mr. Lawrence.
Yeah. Okay.
What's going to happen on her?
She's maintained that she's innocent.
Oh, okay. Oh, yeah. I didn't know where that was heading.
Okay, let's see.
Then you just set that one for trial.
It's set for trial.
Oh, is it? Why didn't we have it today?
It's only an announcement.
She's maintained she's innocent. So we're going to set it for trial.
Oh.
Okay, well, we'll just set that one for trial and then get this other one on March. Yeah, he's going to talk to you here in a minute. Y'all got to sign some documents here that are on that pad.
How much you sign?
Probably.
The old $500 fine.
Once again, he goes silent. He seems to have a need to do that today. Let's stay in Texas, but go say good morning to Judge Boyd.
Deputy, could you move them to the other end? Yes. All right, Mr. Dixon, if you'll come forward. Court is calling 2024 CR 012476 State versus Clinton Dixon. Can I have parties announced?
Robert Featherston representing Mr. Dixon.
And are you Mr. Dixon? All right, you entered a plea to robbery and also a plea of true to the enhancements on November 6th.
That's correct, Your Honor.
Yes, this is taking a while
has.
because people in jury trials and other things and witnesses unavailable. According to your plea bargain agreement, punishment is to be assessed at a cap of 15 years in the prison. There's a $2,000 fine. The state is opposed to your application for community supervision and opposed to your application for deferred adjudication. They're taking in consideration 2025 CR 001601 and 2025 CC 014159. Have both parties had a chance to review the PSI and TAP evaluation?
State has, Judge.
Yes, Your Honor.
Any objections to the PSI and TAP evaluation, state or defense?
No objection from the state.
No, Your Honor.
All right. So both parties agreed that witnesses would be allowed to appear by Zoom. So there are 2 witnesses by Zoom. 1 witness is for the defense and 1 witness is for the state. State, you're opposed. Are you ready to proceed?
We are ready to proceed, Judge.
All right, you may proceed.
Yes, Judge, we'll be calling Mr. Nakubula next instead.
All right, if you'll spell the name for the court reporter, please.
Just to be clear, Judge muted herself right there. We'll ride with it for a minute or two, see if that corrects itself. Hang tight.
All right, the state has called their first witness. Their witness is by Zoom. Any objection to the witness appearing by Zoom? Defense?
No, Your Honor.
State?
Not from the state, Judge.
All right, so the witness by Zoom on Samsung, can you please unmute?
Yes, ma'am.
Counsel, are you requesting that their video be shown or no?
No, Your Honor.
All right, could you raise your right hand for me, please?
Yes, ma'am.
Solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Yes, ma'am. My hand is up.
All right, the court will note for the record that the state and the defense have previously tendered to the court reporter the witness's name and the spelling of that witness's name. And everyone is in agreement that the witness is who they state they are?
The state agrees, Judge.
Yes, sir.
All right, you may ask your question, state.
Mr. Nick, can you hear me?
Yes, sir.
All right, how are you doing today, sir?
Good.
Good. Okay, let's go to the night of the robbery. Can you, piece by piece, tell me what happened that night?
Yeah, actually, I work on that store, like morning shift. I came like in early morning to open the store, and the guy walked to my car and was asking some money, or I don't know what he was asking. Then he was waiting there, so I locked my car and I went inside to the store, but he was outside the store and waiting there. So I was working inside to fix, some stuff and arrange the beer and stuff like that and put ice on it. And he knocked the window, like the door, to open the door for him. So I said, just wait. He said, just open the door.
Mr. Nick, just a quick second.
Yes.
Person that was knocking on the window, can you see what's going on in the courtroom right now?
All right,
Yeah.
let me ask you this. Do the
Yeah,
parties
this guy.
stipulate that the person that the witness is speaking about is Mr. Dixon?
We do, Your Honor.
All right.
Okay, thank you, Judge. All right, Mr. Nick, tell me what happened next?
Okay, so when he knocked the window, he said, open the door for me. So I opened the door for him. He said, I want to play the quarter machine. But he was not playing the quarter machine. He just started shaking the machine because there is some quarter and money in it. He started shaking that. I said, don't shake the machine. You need to put the quarter. He said, no. Okay. Then he went, then he walked to the other game machine and sat there. There was like $100, like a receipt. Somebody else was cashed that ticket, and he said, look, I won the $100. I said, look, this is not belong to you, that's belong to somebody else. He left it there. He said, okay. Then I know like he gonna do something. Then he walked to the lottery ticket and he start pulling the lottery ticket from the lottery slots, like 2-3 ticket. Then I stop him. Don't take the lottery ticket. You need to pay for it. He said, no, I need to take it. I need it. I said, no. When I stop him, he push all the lottery ticket boxes, like push it and pick up the whole boxes and run with the lottery ticket. Then I run after him to get the lottery box from him. And I was telling him, give me the lottery box. He was not giving me. When I hold his lottery box, then he hit me on the face. And I was like bleeding, and my nose was bleeding, my face was bleeding, like the forehead. He hit me with the breast knuckle punch, something like that. I don't know. He has a medal on his finger.
Okay, so you were bleeding from your nose as well as the side of your head?
Not like a nose, but my nose hurt at the top of the bone. It was bleeding. Not like inside, but the top was bleeding and my forehead was bleeding. I have the picture and everything.
Okay.
And the cop will have the picture too.
Mr. Neck, have you had any ongoing injuries or ongoing pain from this incident?
Yes. So right now, as I say, like I have especially during cold weather, I have my nose is hurting and my forehead is hurting, and I'm taking like a Excedrin, and every time those pain, like the pain medication.
How long have you had this pain? Since the incident?
Yes.
Okay. And this is going to be a weird question, but I need you to answer honestly, Mr. Neck. Did you at any time try to solicit sexual relations from the defendant?
No, that's kind of I don't know why he said that. That's kind of silly accusing, to be honest with you. That's not true and that's not right,
Mr. Neck, did you do anything from your point of view that would provoke the defendant?
Say what, sir? I did not get it.
Did you do anything or say anything that would have provoked the defendant to assault you?
This kind of question, to be honest with you, I can't get it. So sorry, sir.
That's okay. That's okay.
Can you explain it like a little bit like basic?
Were you aggressive towards the defendant, or were you just trying to get the tickets back?
Oh, he needs to get a punishment. I'm not gonna forgive him because he messed up my life.
Thank you, Mr. Neck. We'll pass the witness.
Defense.
Mr. Nick, can you describe your assailant on that day?
Say what? Assailant what?
Can you describe your assailant? What was he wearing?
The guy? Man. To be honest with you, I don't remember. Maybe like a black clothes or something like that. I cannot remember it, to be honest with you, what he was wearing.
Well,
but he's this guy. I see it.
How long was that person's hair?
It was long. It was long.
Were they wearing makeup?
I don't know. That's why I cannot remember it, to be honest with you. So I don't know. But hey, I remember like his hair was long. It was this guy.
Well, Mr. Nick, isn't it true that indeed you did try to solicit sex from Mr. Dixon on that day?
No, that's as I said, like that's kind of silly accusing that he did. But I said like he was asking money. He just came inside and stole the ticket and run on the ticket and take the ticket out. And how I'm gonna be doing this? This is kind of like a silly accusing. No, that's not true.
Mr. Nick, isn't it true that when he did go inside the store, you continued to harass him? You continued to ask for sexual favors? and that in retaliation, he took those tickets and left the store. You did have a physical altercation outside the store, correct?
No, look, inside this, it was, look, this is a kind of, as I said, this is a kind of silly accusing, you know? He asked the money from outside and he was waiting in front of the store. And when I opened the door, he came inside and he was waiting on the chair again. They have a video, they have everything. If you guys can ask from my boss, they might have a video and they can share it with you if they have it right now. And they have a pictures. No, that was not true. He grabbed the ticket and I stopped to do not take the ticket. You know, he said, no, I will take it. I said, no, you cannot take it. When I grabbed him, you know, to take the ticket from him, he pushed the whole lottery box and take the whole lottery box and run with that one. So I run
Hey,
after
Mr.
him
Dick.
to take the lottery box from him. Then he hit
Mr.
me.
Dick.
Yes.
Okay, you indicate that you've had medical issues since this incident. Did you go to an emergency room for any of these
No.
incidents?
No, the ambulance was there. They put a bandages on me. They said it's kind of really deep, you know, that they hit you if it was too much bleeding. So go to the ER. They're gonna suture your wound. But but I
Mr.
did
Dick,
not go.
isn't it true? Isn't it true that you refused medical attention at the scene?
No, I did not refuse it, but they put a bandages on me and I said, okay, if I need it, I will go to emergency. But I did
Mr.
not
Dick,
go on that day.
Mr. Dick, did you ever go to a doctor concerning your injuries on this particular incident?
No, I did not go to any doctor, but I have a
So,
headache, as I
so
said,
Mr.
like a.
Dick, it's really safe to say you have no documentation of any injury associated with this event, correct?
But I have a headache. As I said, I have a headache and nose pain. So I
Well,
don't know. I probably see the doctor in the future, you know, but I don't know right now. But as I said, like I take like a pain medication. Every time when my head is hurting, my nose is hurting, I take pain medication.
Pass the witness, Your Honor.
State.
No further questions, Judge.
All right, is the witness excused or subject to recall?
We have the witness speaking.
Excuse, Judge.
All right, thank you, sir.
No problem, ma'am. Thank you.
All right, state, any other witnesses?
No further witnesses, Judge.
Defense, any witnesses?
I do, Your Honor. Call Dr. Joanne Murphy at this time.
All right, Dr. Murphy, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? Oh, you're on mute. If you can unmute. Thank you.
She's still on mute.
I just sent her a request.
There we go.
Can you hear me now?
Yes, we can.
We're good.
And your answer to my question?
Yes, and I did say I do.
All right, thank you. You can lower your hand if you'll state your name for the record.
My name is Joanne Murphy.
All right. Defense, you may proceed.
Thank you, Your Honor. Dr. Murphy, what do you do for a living?
I'm a psychologist.
Do you handle court-appointed criminal cases?
Yes, I do.
How many court-appointed criminal cases have you handled over the course of your career?
Well, certainly more than 100, maybe more than 200.
Okay. Your practice is general psychology then?
Yes, and forensic work, both criminal and civil, do a lot of family law work. And I see patients. I have a practice as well where I see people with difficulties.
Good. And Dr. Murphy, how long have you been practicing?
I've been licensed for over 50 years, first in Tennessee in 1975, and then in Texas since 1985.
All right, thank you. And Dr. Murphy, did you have a occasion to examine Clinton Dixon?
Yes, I did.
Okay, and did you prepare a report concerning Mr. Dixon?
Yes, I did.
And Your Honor, at this time, I've already provided a copy of that to the court through electronic filing. Has the court had a chance to examine that?
I actually have not received that. Do you have a copy for
I
me?
do, Judge. Do you want me to mark that and make it a part of the record?
If you wish to, otherwise I'll just take judicial notice of it if there's no objection and I'll review it.
Okay,
No objection from the state.
then we'll just do it in that fashion.
All right.
Dr. Murphy, did you have to have more than one session with Mr. Dixon?
Yes.
What was your impression of his history?
My first impression of
Well,
Mr.
no,
Dixon?
your impressions of his history. What did you think of his history?
What did I think of his what?
His history.
Oh,
Let me break it down. What did you think of his family history?
that he had a very difficult early and growing up. His parents were pretty much not in the picture. He was bounced from parent to parent, and then most of his life reared by a grandmother who was at times pretty nurturing and also at times pretty abusive. There was a lot of physical abuse from both parents and from this grandmother, who also could be a source of comfort. And when he misbehaved, dealt with him very severely.
With respect to his biological parents, can you opine about their involvement in his life?
It was off and on. He would sometimes live with a parent, but it almost always resulted in going back to grandmother at some point.
Were the parents homeless?
Yes, at times.
Based upon your evaluation of Mr. Dixon, did he receive any adequate supervision as a child from his parents?
No.
Did Mr. Dixon have any problems with the juvenile system?
Yes.
Do you think that was due primarily to lack of parental supervision?
And also ADHD, untreated, undiagnosed, probably.
Okay. Now, when you talked to him, did you discover that he might have had PTSD also?
Yes.
Okay. Where do you think the PTSD extended from?
Well, he was pretty much always in trouble. He was in trouble at school. He would be expelled. He would be in trouble at home and a lot of physical abuse. And then, of course, at age 15, he is certified as an adult and sent to TDC.
How long did he stay in TDC?
A long time.
15 years?
I don't remember precisely how many years, but I know he was transferred from one TDC to another. He was out for a short period of time and then was incarcerated again.
Did he have any attempts at suicide while at TDC?
Yes.
Do you remember how many, or was it just multiple?
I don't remember how many.
Okay. What did he get a GED while he was at TDC?
Please repeat.
Did he get any education while he was at TDC?
No, and he had finished the 8th grade.
Okay.
Right, and I'm so sorry to interrupt. And this is a question that I have. I hope nobody has any objections to me
Go ahead.
asking defense counsel, since I'm trying to make a decision on what to do in this case. So are you saying that he was sent to prison when he was 15? And I read the report that you gave me and I reviewed the PSI. So you're saying he was sent to prison at 15 and he did 15 years and
That's
did the
correct.
entire 15 years.
He did.
So that would mean 15 plus 15 is 30.
That's correct.
So then, and this is alleged to have been committed, well, not alleged, this offense was committed when what, he was 31 or 32?
That's correct, Your Honor.
Okay, I'm just trying to get the dates in my mind. All right,
Would you like me to proceed now?
yes.
Okay, thank you, Your Honor. Okay, so Dr. Murphy, did he pick up any other mental health issues while in custody for that 15-year period?
I don't have any records from his TDC or anything like that. So I don't know.
Okay, was he sexually abused while he was in custody?
Yes,
Did that only happen once, or was it multiple occasions?
it was continuous.
Did, from examining him, did you determine whether he got any mental health therapy while he was in custody?
None. When he reported this, he was transferred to another unit. The sexual abuse continued. It was giving oral sex and receiving anal sex. And it was daily, weekly, it was continuous.
Was his appearance as that of a male or female while he was in custody with the state of Texas?
Well, as he entered to this date, Mr. Dixon has not had any consensual sexual activity. He didn't enter TDC feeling that he was homosexual, but he now, I guess, would consider himself transsexual, and believes that his identity should be as a female because he's had 15 years of continuous sexual activity while incarcerated.
Judge, have you ever, I'm sorry, Dr. Murphy, have you ever heard of the term girly boy?
Yes,
Does that apply to Mr. Dixon?
not to my knowledge. I mean, he was acting out, he was aggressive, you know, he would get in trouble. I don't see anything or have heard anything that he was a girly boy.
With respect to your conclusions on Mr. Dixon, could you tell the court what you think should happen with him?
You know, I think this is a horrible case, and I don't know. This is a young man who has received no appropriate care throughout his life. He's spent more time in prison than out. I think the history is horrible. He's had drug and alcohol problems. He's had no treatment for that. He's had no treatment for attention deficit hyperactive disorder. And now we have a gender issue here. I just think this is horrible.
Dr. Murphy, do you think he needs mental health treatment?
Absolutely.
Do you think he needs drug treatment?
Absolutely.
Do you think he needs education?
Absolutely.
When you tested him, what level of education do you think he was at?
I didn't do academics on him, although his cognitive functioning was in the somewhat below average range, but you've got to take into consideration that education ended at 8th grade. So he wouldn't have had the opportunity to have attained higher cognitive skills.
Dr. Murphy, do you think it's in the best interest of society that he receive a probation program?
This man is going to need to be supervised, clearly. But I think what has happened to his history is absolutely horrendous.
Judge, I'll pass the witness.
State.
Few questions, sir. Dr. Murphy, you said that the defendant would need to be supervised.
I'm having a little bit of trouble hearing you. Could you Speak a
I'm so
little
sorry.
louder, please.
I'm so sorry. Doctor, you said that the defendant would need to be supervised. What are you basing that on?
His history.
Do you think, while talking to the defendant, did you review any of his previous disciplinary history while incarcerated?
I reviewed the criminal history of Mr. Dixon, starting from 9/21/24 to October 25. So I'm aware of the testimony about the lottery tickets, the stolen vehicle. I'm aware of that reported history.
Okay, thank you, Doctor. I'm sure, Doctor, are you familiar with what is it? Oppositional defiant disorder?
I'm sorry, I'm still having trouble hearing you.
Said, are you familiar with oppositional defiance disorder?
Yes, I am.
Did you receive any indications or any presenting by the defendant that he may have some kind of oppositional defiant disorder?
Well, when you have unmedicated ADHD, you're going to have symptoms that are similar to oppositional defiant disorder. And it may be hard to separate what is what. But certainly there were times that his behavior had some characteristics of oppositional defiant disorder.
Thank you, Doctor. Now, last question I'll ask you. Probation is going to require the defendant to attend classes, make meetings, pretty much keep to the rules and abide by a very tight schedule. Do you believe that he would be successful and be able to abide by all the rules of probation?
Only if he has stable living and stable support
Okay.
in his community.
Thank you so much, Doctor. I appreciate your answer. We'll pass the witness, Judge.
Dr. Murphy, based upon what you know about Mr. Dixon, well, let me back up. Dr. Murphy, can you explain to the court what a triggering event is?
Yes, it's an event that triggers some previous trauma.
For instance, if I had previously been addicted to cocaine and I walked into a room with cocaine, would that be a triggering event?
It would, very likely.
If I had been previously the victim of sexual abuse and someone attempts to solicit me for sex, is that a triggering event?
Very, very likely.
Thank you, Your Honor. Pass the witness.
No further questions, Judge.
All right, any other witnesses?
No other witnesses for the defense, Your Honor.
All right. So this is, and no witnesses for the state.
No, we had our one sole witness.
All right, this is what I'm gonna tell the parties. One, this is gonna be something that I'm gonna need to think about for like 15 or 20 minutes, and I will tell you what my thoughts are, and then you all can give me your arguments and maybe address the thoughts that the court is having. Before me, I have somebody who went to prison at 15. And I keep telling people things happen in prison and people think I have some personal control over whether or not you're just allowed to do your time and nobody's gonna bother you. And I keep telling people rape and everything else happens at a prison. So I'm considering the fact that he's 15 years old, he gets sent to prison and he does the full 15. Now, I may be wrong, and if I'm wrong, let me know I'm wrong and I won't even consider it. But when usually, from my experience as a defense attorney, when you do the whole 15 years, either one or two things are happening. Either you're getting in trouble at the prison, maybe it's your fault, maybe it's not your fault, or either you have a complainant who comes to prison every time and says, do not give this person parole. And then I'm looking at the fact that he's a product of CPS, which I always tell everybody, the government does not raise children very well. CPS workers are overworked, underpaid. So these are some things that I need to think about when I'm considering all of this. Because Mr. Dixon, I look at the entire life of a person, not just the incident, because if you just look at the incident, then it's an easy decision. And I'm also looking at the fact that for some reason, his name is Clinton Dixon. Then he has another sibling that they decided, some father, I guess, who thought, hey, I'm a great dad. Let me name this other child Clinton Dixon as well. So if y'all can formulate your thoughts on that while I think about a few things, and y'all can come back at 10:30 and I will have made a decision.
Thank you, Your Honor.
All right, thank you. Thank you, Dr. Murphy, for giving me some insights.
So this one is interesting, and we'll definitely rotate back here when they come back. So as I understand it, we have like this robbery or whatever, assault, whatever went on there. But this is a defendant who was put in a prison at 15 as an adult. And it seems like for 15 years he was taken advantage of in that prison. But does that mitigate his responsibility? These are the questions. So yeah, I'll be curious to see where this one goes. Let's stay in Texas. Back to Judge Stevens. The guy from earlier is back.
Reading of the indictment and arraignment. Can we proceed in summary?
Yeah, yes, sure.
And in summary, sir, this indictment alleges that on or about April 10th, 2025, in Jefferson, it's on its way up. In Jefferson County, Texas, this alleges that you committed the third-degree felony of unlawfully carrying a weapon in a prohibited place, which was namely Lamar University, Beaumont, Texas. Do you understand what you were charged with?
Yes.
If convicted, you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement has been reached, you would be pleading guilty, placed on deferred or unadjudicated probation for 10 years. There's a fine of $500. Is that right? Did I hear?
Sure.
Are there any other terms and conditions of probation?
Probably stay out from the mall campus.
Or were you a student there?
I went to LIT, the other campus.
Okay. Or are you still at LIT?
I was in the real world. Yes, sir. I was alone.
I'm not sure what their rules are about that. What do y'all say about it? I don't want to butt in, but I don't.
I would say, can we put a caveat of stay off the campus unless attending enrolled courses?
What were you doing on there in the first place?
I was visiting a friend.
They were in the dorms, Your Honor, I believe.
They were what?
They were in the dorms, I believe, when this occurred.
All right, there will be terms and conditions of probation that are normal and customary, plus you are disallowed from being on any of the Lamar University or Lamar related campuses except for purposes of school.
Yes.
So where you were enrolled and you were attending class.
Yes.
Just don't carry it again.
Don't do that again on our schools in a school zone.
Yes, sir.
Even though it's so long.
If I follow this agreement, you have no right of appeal of your case. Do you understand, sir?
Yes, sir.
How do you plead to this charge, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will.
Yes, sir.
And because you are guilty.
Yes, sir.
You know, the bar is not showing, the bottom bar is not showing on this for some reason.
Tablets are messed up.
No, I'm talking about on the screen. I can see the date on the tablet, but I normally refer to it up on the screen, and I'll see it. I'm going to show you, sir, what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into us.
No objection.
Without objection, it is admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, or you've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Correct? States Exhibit 1, part of the record without objection. Pre-sentence report is waived.
So
I will follow this agreement and I will find you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. Even though there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, I'm going to defer or postpone any finding of guilt so long as you follow terms and conditions of probation. Probation officer will go over with you. Most of these terms of probation are terms that we all have to follow, like don't commit a crime, don't associate with disreputable people. But there are other terms and conditions of probation which we're not required to follow, but you must, such as don't use or possess any drug unless otherwise allowed by prescription, and again, you will stay off of Lamar University campuses unless you are enrolled in campus and enrolled in school and are attending class. So you will be placed on 10 years deferred or unadjudicated probation and a fine of $500. And you do well, it can be shortened to 1/3 of 10, which is 3 1/3. 3 1/3 years. So it could be shortened to that. Anything else? Please see the probation officer. Thank you.
We're going to rotate back to Judge Boyd in a second. She has a new contestant, but creeping up on the 4th hour, only about 40 minutes away. We will at least start with doing more court in hour 4. Bailey, since you haven't been here for a while, we have a 4th hour now. Sometimes we just watch court. Sometimes we have debate on the things that we've seen for the day. Other times I dig into court and law news that we don't necessarily see in the courtrooms that we follow. So every day is a little different, but today it's probably going to be more court. Anywho, let's get back to Judge Boyd.
Yeah. This up. Hi. Hello. Morning. Morning. I'm sorry, my computer has been very slow today.
It's okay, Judge. Do you want my copy?
Oh, it's pulling up. It's coming up now.
And I could just give you a quick synopsis. So Ms. Medina is here because there was a supplemental report submitted to the court indicating some possible compliance issues. It was reported to the court that there was some inappropriate behavior while doing while she was at a office visit, and then there's been marijuana use, and basically that's it, Judge. We do have some information to provide for the court.
Yes.
So she's in the dual diagnosis outpatient program currently. There's been 18 positive UAs for marijuana. She's been trying to get a medical marijuana card because of some physical medical issues that she has. However, what's hindering her from getting that card is getting her medical documentation from the doctors that she visited while she was in Corpus. She has asked probation to allow her to go to Corpus for a day just so that she can obtain all of the records she needs. However, I think during that visit is when the inappropriate behavior happened. And at that time, probation said no. So she is well aware of how she should conduct herself during office visits. And we've talked about that, and she knows what to do going forth. She is asking the court's permission to go to obtain her medical records so that she can be in compliance with everything that she needs to do as far as the marijuana use is concerned. She's completed her anger management program, and like I said, Judge, she's currently in the dual diagnosis outpatient program.
All right. So if you're angry and upset with people, right? How does that help you obtain what you're seeking to obtain? If you're shouting at people, if you're being belligerent at people, it doesn't help at all. So because you did that, you're still not in corpus. They denied your right to go to corpus. Right?
Yes, ma'am.
All right. So being belligerent to people and not being nice to people, that really doesn't help anything, because when you're belligerent and you're not nice to people, unless they are paragon of society, they usually are not nice back. And then I find that when people start shouting at each other, then they're really not listening to each other. It's just like, get out of my office. I don't want to deal with you because you're trying to ruin my good day. And I don't know how many times I have to say it to people. If there's an issue, let your probation officer know about it. If you feel as they're not addressing it, you can still come to court and address it with me.
I was not aware of any of that like that.
No, I say that every time. To every person who's on probation, I let them know that. But the one thing we don't do is try to ruin people's day by being mean and disrespectful. Because I guarantee you, the probation officer you spoke to, they're not paid enough money for what they do. Right?
Yeah.
And then they're dealing with somebody who's coming in being disrespectful to them, ruining their day. Sometimes you may be the only person that stops somebody from just throwing their hands up and losing it. So it's always nice, even if you are having a bad day, to greet somebody with a smile and a hello. You don't know how that may impact their day. And you negatively impacted somebody's day. And so they negatively impacted you by saying you're not going to corpus. You understand?
Yes.
So we don't do that here. I require that everybody treats everybody with respect. And even if you don't respect them, pretend. You understand?
It's a golden rule.
All right. So what are you requesting, probation?
Judge, so at this point, we are requesting that Ms. Medina have the ability to go ahead and go to corpus, obtain what she needs to obtain, and move forth with getting what she needs to get for the medical compassionate use program. I'm also requesting, once she becomes compliant, Ms. Medina has expressed the need. She hasn't seen her family in quite some time, and her family lives in the Valley. She says she hasn't seen her father, and she would like to go to the Valley to visit her family.
Do they want her to visit?
I had to cut them off from so much that I kept making them wait on me.
Well, no, here's the thing. Sometimes people say they want to visit family. And I'm always wondering whether or not family wants them to visit, because I don't want people who are on probation to end up involved in situations that they're not ready for. So that's why I'm asking that question. So do you know if they're ready to see you?
They've been waiting on me.
Well, when's the last time you spoke with them?
About a month ago.
All right. So I tell you what, I will strongly consider allowing you to do that. But what I need you to do is have them reach out to probation to let probation know that they would like to have contact with you. And if their answer is yes, And if everything else is taken care of and you're doing well, I will sign the order for you to go visit with them. Okay? So whether or not you visit with them, a lot of it's going to depend on you getting what you need in order to do that. First thing, get them in contact with probation for them to say, yes, we want her to visit with us. And then that probation is going to need to know where you're going to be staying when you go visit. And then when you come back, you'll have to do a UA upon return. You understand? And if that's yes or no.
Yes, ma'am.
And if this medical report you need from its corpus,
Yes, Judge.
if you're not able to get that and you don't get a card for use for marijuana for medical purposes, then you're going to have to start doing something else, because you're not allowed to smoke marijuana while you're on probation or use marijuana while you're on probation unless you have a medical prescription. Do you understand?
Yes, ma'am.
All right. So when is this trip for corpus needed? What day?
As soon as possible, because I did call in order for me to.
No,
get
what
them.
date?
If anything, tomorrow, I'm able to go as soon as
All
I'm
right.
able to be let go.
And how long are you're going to need to be there?
As long as the offices are open, majority of the time they're open till 5.
All right.
That one day, Judge.
All right. So she's allowed to leave. February 13th. You may want to call them, because sometimes doctors' offices, they close early on Friday or they're off on Friday.
And Monday is a holiday for some offices as well, so they may close early.
All right.
So
So,
Tuesday.
so we'll do,
Tuesday instead?
all right. So February 20th.
Is that Tuesday's date?
Oh,
Judge?
is it the 18th? Let me see. Or is it 17th?
17th, Judge.
All right. So February 17th. And I'll put on here, she's allowed to leave February 17th or February 12th, because you may call them and they may say, no, we'll be open all day tomorrow. All right. Is there anything else?
Is there anything else? No, Judge.
All right. So in this court, communication is key. If there is an issue, let your probation officer know about it. If you feel probation is not addressing it, you can always come back to the court and address it with me. All right.
Yes.
Anything else you need?
No.
All right. Good luck to you.
Thank you.
You're welcome.
All right, I'll continue to keep an eye on Judge Boyd, wait for that other defendant to come back, but let's head up to Michigan, Judge Mom.
Good morning, I'm Neil Lloyd here on behalf of Pierce Smith. Mr. Smith, please state your name. Pierce Smith.
All right, thank you. Did that come through? Okay, and do it a little bit more loudly, please.
Pierce Smith.
Perfect. And today is the date scheduled for the arraignment and the pretrial in these matters. And counsel?
Yes, Your Honor. My client waives formal reading and stands muted to the charge.
The court will waive the formal reading, enter a plea of not guilty for purpose of the arraignment as to the pretrial.
Yes, Your Honor. I reviewed this matter with Mr. Smith, also reviewed with the city attorney. My client's prepared to offer a guilty plea to the amended charge of no operator's license on person. The original offense would be dispute. I would also point out for the record, I'm going to discuss this matter with the client. Explain to him that there are licensing sanctions which are beyond the control of this court and we're attorney today. There are no points, but it is referred. So as far as what effect it has on his driving record, that's he understands that that's baked in and you can't avoid that. I also wanted to point out to him that we have discussed that he would like to have discovery in this matter. We raised some procedural issues privately with me, explained what could happen if we were to order discovery. There's no penalty, there's no extra cost to do that. But he advised me that knowing that, he's prepared to go forward and accept the plea today to resolve the matter. Is that correct, Mr. Smith? Yes. Thank you.
Did that come through, Autumn?
Yeah.
Perfect. Sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
And you heard the plea that was placed on the record, correct?
Yes.
As to the amended charge of no operator's license on person, how do you plead? You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights. You also understand by entering into a plea that you'll be waiving some of those rights. You understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes.
And by administrative agency, that could be the Secretary of State.
Yes.
Also, sir, are you on probation or parole anywhere?
Yes.
So that could affect your probation or parole status. Do you understand that?
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, if you can please order your client.
Yes, Mr. Smith, you recall being, operating a motor vehicle on, 4th Street on or about March 17th, 2025? Yes. At that time, you had an interaction with a Wyandotte police officer? Yes. And during that interaction, you did not have a valid license on your foot, is that correct? Yes. Or I'm satisfied with that.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And as to sentencing counsel, you asking for immediate sentencing?
Yes.
Okay.
Same, if I could say a few words,
Yes.
about Mr. Smith. Mr. Smith is gainfully employed, he's employee of the city of Detroit, as an animal control officer for, past 3 years, is that accurate, sir? Something else I think that, I think the court might take interest in his spare time, he's a motivational speaker. He speaks to inner city youth. He has a story I'd like you to hear him tell you about what brought him to that, but he works with a program called Prison Wives Turn to Bosses. Is that correct? Yes.
Prison wives turn to bosses or lives?
Wives.
Okay.
One, there's an activist who has started a program and he participates in the program. He gets a lot of personal satisfaction out of that. But if the court wants to hear a little bit of the background of what brought him to that, I think it might give you an idea of the character of Mr. Smith.
Okay.
Well, back in 2024, I was shot 5 times by my best friend. When I came home from dialysis in the nursing home, I ran into a lady named Latoya Perry. She told me my story was interesting. She would like for me to follow her and go speak to the youth while she speaks to the older people, the generation that she speaks to. And so since then, I've just been waiting off and I go to different juveniles from Macomb County, St. Clair Shores. This week, I'm supposed to go to Toledo, Ohio. And that's what I just do when I don't work at the animal shelter.
Okay. And sir, how do you get to those places?
Well, she pays for our trips because we all ride on the bus together.
Okay. And at the city of Detroit, or do you work animal control with a partner?
I work for the city of Detroit Animal Control Office.
I understand that. So do you work with a partner or are you on your own?
Yes.
Okay. And what is the message that you give to the youth?
Well, I tell them, back when I was growing up, nobody ever told me, like, what's the last 4 letters of friends? ENDS, all of it come to an end at some point in time. I always thought, friends is always there forever. I would never tell me, like, when you get older, you gotta wing off and do things your own. You gotta understand that no one's gonna be here with you forever, no matter who they are. They can be, you can know for 20, 30, 40 years. Never know.
Right. Interesting. ENDS. The first 3 letters are FRI, which could be fry, right? Sometimes your friends leave you out to fry.
Yeah.
Right? They're not really your friends. So, sir, how long have you been doing that?
I've been home for about 1.5 years now. So I should stay up to it's almost 1 year now.
Okay. And so, why do you keep driving?
Well, I only drove that day because we had to get a call to a dog was mauling up a child. So what I do is I decapitate a lot of the dogs. And there's only a few of us there that can do it. And I had to get there so we can decapitate the dog to stick the head out to see if the dog had rabies because the kid had to go to the hospital.
Okay. So why don't you just hop in an Uber or a Lyft?
To be honest, it was a random sitting right there. I didn't think about it. I was just trying to get there the quickest way possible.
I get it, but Uber and Lyft drivers are a dime a dozen in this area because, right, it's a very highly populated area. So you could probably get there and it would have been a lot less expensive, right?
Yeah.
Okay, how'd you get here today? Okay, how much did that cost?
Well, I stay up the street, so it was like $10.
Okay, let's see your app. Pull it up.
But my phone is actually not to the charge me when I leave. I gotta order another Uber to get home, so phone going to sit by the bathroom.
By the bathroom, you just left it out there unattended?
Yes. I mean, I had to keep it charged so I can get home.
I know, I understand, but you would hope that in a courthouse, you could trust people that are here, but hopefully. All right, sir. You're not driving anymore? Okay, and you want to get your license back, right? And so what do you need to be able to get your license back?
Well, they told me right now is one that I'm hoping of. I can wait for a court date. And finally, I got a court date today, so now I can step forward to see what else I need to do.
Okay, so you do know that if you want to get your license back at any reasonable time in the future, that you really should refrain from driving,
Yes,
correct?
yes.
Okay. Do you have another case in this court? Can you pull up 25-381, please? I'm just checking something, sir, to make sure that there isn't something that's,
25-381.
yes. Is there not a case number for that?
Yes.
Okay.
No. Oh, no.
Okay, so there's nothing pending for Mr. Smith. Okay, just want to make sure, because there was another case number on your receipt, sir, and then for your bond, and it was moved to this case, so I just wanted to make sure there wasn't another one that maybe you had forgotten about or something, so. All right, here, sir, I'm going to do you a solid, all right? I'm going to order a $100 fine, crime victims fee of $75, justice system assessment fee of $50. So that is $225. I'm going to order $25 in costs, so we can apply your bond 100%. You don't have to pay any more money out of pocket. Okay? So I've been told I'm the worst judge in the world. So you're going to see that if you are back here again driving. Got it?
I promise.
Okay. All right. Have a good day, sir. Just stop over at the window in case you have to sign something over, okay?
All right, thank you.
All right, you're welcome. Good luck to you.
Thank you.
All right, and so we are on the record in the matter of the state of Michigan versus Chadwick 2655. Okay, good morning, Mr. Stamper. Okay, you're waiving your right to an attorney?
Yes,
Okay, we have a waiver that we need you to sign, and then we'll call this matter up, okay?
I believe I already signed it.
I don't, well, let me see here. Oops, yep, it's on the other side. Okay, I missed that. No, that's okay. Okay, so, sir, your name for the record, please.
Chadwick Stanford.
Okay, please keep your hands out of your pockets. Today is the date scheduled for your arraignment and pretrial in these matters. And sir, do you know why you're here? Do you want the court to read the charges, or do you want to waive the formal reading and continue with the proceedings?
You can waive the formal reading.
Okay, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And sir, you had an opportunity to speak to a prosecuting attorney today, correct?
Yes.
All right, and there seems to be a resolution, correct? Are you picking them up?
Yes.
Okay. And so, sir, what is the nature of that resolution for the record?
The nature of the resolution was that the driving while license suspended second offense was going to be dropped, and I was going to plead guilty to the low option person.
Okay. And sir, I am required to inform you, I know that you've reviewed this document and that you've initialed, but I'm required to inform you, sir, that you do have the right to have an attorney represent you in all critical stages of the criminal process. And that this stage is one of those critical processes of the criminal or critical stage of the criminal process. Do you understand that, sir? And you do understand, sir, that if you wanted to have an attorney represent you, you could have one appointed to represent you at no cost. Do you understand that?
Yep.
And knowing all of that, do you want to continue this process representing yourself?
Yes.
And you did in fact initial this document, correct?
Yeah.
And you read this prior to initialing it. Is that also correct?
Yeah.
Okay, and that document would be 27th District Court, Michigan Indigent Defense Council Program Waiver of Attorney.
Yeah.
Okay, and so, sir, I'm going to have you please raise your right hand. You solemnly swear or affirm testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Okay. And sir, as to the pretrial that you're going to be pleading guilty to no operator's license on person, how do you plead?
Yep.
And you've gone over your advice of rights, correct? And in fact, you signed that document. Is that also correct?
Yes.
Did you have any questions regarding those rights? You understand by entering into a plea that you'll be waiving some of those rights?
Yeah.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yeah.
Which that administrative agency could be the Secretary of State. Also, are you on probation or parole anywhere, sir? Okay. And so knowing all that, do you want to continue with your plea?
Yeah.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Sir, on the date in question, that being January 8th of 2025, were you in the city of Wyandotte?
Yes.
And you had police contact at some point, correct?
Yeah.
And you were operating motor vehicle, is that also correct?
Yes.
And upon request of the police officer at what seems to be a subsequent traffic stop, you were unable to provide a valid operator's license to the officer, correct?
Yeah.
And that was in the city of Wyandotte, is that also correct?
Yes.
All right, the court does find the plea as knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And sir, are you asking for this court to oppose immediate sentencing?
Yeah.
Or do you want to come back for a sentencing date whereby you would have a pre-sentence interview and the court would receive a recommendation from probation?
If we could wrap up this today, I would appreciate it.
Okay, great. What would you like the court to know, sir?
Like you guys know.
Right, about the offense or about you?
That's it.
Okay. Well, sir, what's the status of your license?
It's still suspended.
Okay, why is it suspended?
I have a default judgment that was entered against me back in 2019. And I tried to file a motion to set it aside because
Were you incarcerated in 2019, sir?
Yes.
So you really, I know that you've declined attorney today. However, you really should speak to an attorney because if you were in custody when a default judgment was entered against you, that would be a grounds to set aside the default judgment.
And I'm completely aware of that, Your Honor. And I actually talked to the court administrator at 36, and she's the one that kind of helped me with the process of filing the motion to set it aside. I filed all my documents and everything. I can't pull up the case. It's not pulling up nowhere on the state's case website. I've called the court a couple times. They said that they assigned it to a judge, but they're just like the judge is waiting for I don't know what. And it like
What is the charge in 36 District Court, sir?
it was for a default judgment because In 2018, I was in a car accident and my passenger was injured.
Oh, so is it a default, like, is it a
It was like
a financial oh, okay, okay.
Signed claims. That's what Secretary of State, when I was released, I came home in 2023 and I went down to Secretary of State. I paid off I had like a couple of tickets in Lincoln Park that they wouldn't do a plea by mail. So I had to clear up some of those tickets. And then Secretary of State's like, oh, well, you have this assigned claims. It's like 10 grand. You gotta deal with, and they gave me a number to this debt collector and I had to pay like $500 down. I was paying $150 a month. After and they gave me my license back. They lifted the hold off. I had my valid license and everything. And like 4 months into it, I made my payment. And like 2 days later, the debt collector called me and they're like, oh, well, it's showing that your payment didn't go through. So you're gonna have to make another payment. I couldn't afford to make another payment. And I tried to explain that. And when I had seek counsel at that time, and they told me a little bit about how shady debt collectors could be and stuff. So when I did that validation letter, I sent to the debt collector, they sent me back, and that's when I was aware that it was a default judgment that was actually entered against me.
As a result of you having a debt collection agency?
No, it was
prior to that.
It was from the car accident.
Right.
From 2019. And when that whole litigation was happening, when they tried to sue me, essentially, as the insurance company that tried to sue me. And I was never made aware of that. So when I came home, Secretary of State said you had a signed claim, and she mentioned something that looked like it was a car accident. Like, okay, I'm aware of what it is, but I had never been certain.
So what motion did you file, sir, in 36th District Court?
I filed a motion to set it aside or vacate it. And I can't think right off the top of my head the exact Michigan court rules.
Right.
I was using for it, but I was using it for essentially because I was never made personally aware.
When did you file that motion?
It was November 4th, I believe.
Of 25?
25, yeah.
Okay. And so, sir, why were you driving on January 8th of 2025?
Honestly, I'm not going to make an excuse.
That's fine.
Made a poor decision.
Great. Okay. How many more poor decisions have you made? Do you continue to drive?
No. That's why she had to miss work to bring me here today.
Okay. And so where do you work?
I'm unemployed right now. And that's one of the biggest obstacles that I'm having with finding employment is not having a driver's license.
Okay. And so you reside, okay. I believe in that area, sir, there's quite a few places that you could walk to.
Oh yeah, I've been around. I filled out application, like even Burger King, for whatever reason, like they're like, I fill out application, they tell me I'm like perfect candidate, talking like on spot interview, and then it's just like nothing. No calls back, no.
Maybe after they run your background check. There is also a program, sir, for individuals that have felonies on their record. There's a program to assist with employment that way. So you really need to look into that.
Yeah, I've been looking into a lot of different employment. I know this is kind of off subject, but I have been trying to prepare, like it's an idea, it's a community-based program that I would like to try to start called Evolutionary Seeds for Life. And
Evolutionary
Seeds.
Seeds, okay.
Yeah, Evolutionary Seeds for Life. And basically what it is we try to help engage and communicate within our community, our neighbors and stuff, and try to bring back the practice of like personal gardening or hobby gardening, stuff like that, where people start growing their own food. Because I mean, I'm sure we all can relate to the prices of food is getting crazy. But not only that, but just like bringing people back together, man, to where everybody can come together as a community. If you got certain foods growing, we got certain foods growing, maybe we could swap it out or whatever. But honestly, like I'm really passionate about gardening. Like I have ADHD real bad, and I also have like PTSD. Like it's killing me being in this courtroom right now because of my criminal past and the years that I've already wasted of my life being in prison and stuff, and you know. So it's like I'm trying to find a way that I could kind of share my personal, like what I get out of gardening, because when I garden and stuff, like it brings me a sense of peace, like I can breathe. And I know that if I can share that with other people, man, I feel like there's other people that are similar to me in similar certain circumstances that could benefit from this. And it's just like, not having a license, man, is like your lifeline. And
In this area, you are correct. However,
excuse the fact that I'm breaking the law.
well, no, that was not what I was going to say. I was going to say a few things based upon what you said. And so, sir, yes, you may have made some poor choices that landed you in prison. But you can also look at that as a huge learning experience and take what you've learned from your time that you say was wasted in prison, okay? And do some positive, which seems to be what it is you want to do. What I was going to say also is that the weather is breaking. And so if you have a bicycle, or sometimes police departments auction off bicycles, you can do that, right? Because then you can bike to wherever it is you have to work or what have you. But you should strongly look into the, I forget the name of the, no, that too, but the name of the program that hires convicted felons for employment. There's a program, and there are companies that do that. They give individuals another chance. So you really should look into that so that you can get that information. You can start earning some money, and then can kind of maybe be able to promote your community garden idea. Okay, so here's what I'm going to do, sir. You posted a bond. And that was in your name, correct?
What? Yeah.
Yes, it's in your name. Okay. So here's what the court's going to do. Going to order $200 fine, $100 cost, crime victim assessment fee of $75, justice system assessment fee of $50. Actually, let me amend that. So $100 fine. So your total, sir, is $325. Stop at the window. You'll get some of your bond back, returned to you. It'll be mailed to you, sir. You won't just get it right here today. We send it out we send it out once a month, but we don't have a specific day that we do that. So I can't tell you if it just happened yesterday and it's going to be another month, or it's going to happen the end of this month. I don't know.
Will that be in the form of a check?
Yes.
Okay.
Yes. Okay. So stop at the window, make sure we have your correct contact information, sir, as to where to send the that's your mailing address, and good luck to you. Don't drive. Okay.
Okay, let's do a quick segment that we'll just call Life Advice with Dan. So it sounds like this guy wants to do a side quest, if I heard him correctly, where he wants some kind of community group or something. I forget what he names it, but he wants to help people, I don't know, realize their full potential and, hug psychic stones or whatever, but also garden. Pro tip: if you're gonna have a side quest like that, especially one that's supposed to help others, fix your life first, because you're not qualified. Just that simple. You need to get your stuff together before you start worrying about what anybody else might do or how to help them or whatever. Just a pro tip, just a thought. Fix you first. It's the airplane thing. Secure your oxygen mask before you help the person next to you. Same damn idea. Alrighty, speaking of sitting in judgment of people, let's go to Louisiana.
Hunt. This is the Louisiana Committee on Parole. In panel today at headquarters on my left is Carolyn Stapleton. To my right, Danny Byrod. My name is Jerry Ledoux. Would the offender please introduce yourself with your name and your DOC number? Y'all are muted still. Okay, try.
My name is Julius Will Jr. My DLC number is 598684.
Mr. Wilt, I'm going to be reading some identifying information into the record, and then we'll be asking you some questions. I find that you're a first-class offender currently serving an 18-year sentence for home invasion. You have a parole eligibility date 6/6/2017. You have a good time date 6/13/2028. A full term date 6/8/2029. Is that information correct according to your understanding?
Yes, ma'am.
Mr. Wilt, I'd like to give you the first opportunity to speak to the panel, explain to us why you're currently incarcerated and why you think this would be a good time for us to consider release.
I'd like to say that I failed as a person, a man, and a father. On the night of June 8, 2011, I am fully responsible for committing a home invasion charge on my ex-girlfriend, Jamie, and her 2 children. I violated the privacy of a place that should be a safe place for a family. And it was a cowardly act that I've done. Man, I can't express how remorseful and sorry that I am with the choice that I made that night for what I've done to the family and everybody that I affected making this choice that night. I've changed. I'm no longer that man. I've accepted Jesus as my Lord and Savior. He's just changed the way I think. He's renewed everything about me, my heart, my focus, the trauma that I've suffered throughout my childhood. I believe I demonstrated throughout my incarceration by respecting the authority of the classifications throughout security, male and female. I haven't got no write-ups through the system, and I'm just a completely changed person.
Okay. So have you served 14 or 15 years?
This June will be 15 years.
Okay. Classification, I'd like to ask, how many days CRTP has he received? I see 905. On his master.
That's what we have.
Okay. So in accumulating that many hours, I'm just trying to go through here. Did you get your GED in 2016, right?
Ma'am.
Pre-release, substance abuse, thinking for a change, moral recognition, anger management, moral compass. Okay, I'm just trying to figure out which ones of those classes did you learn the most from?
Truly, it was trauma healing and post-traumatic stress. Because it taught me about the trauma that I suffered as a young child. And when I went through the alcohol, substance abuse and alcohol class, I wanted to try to figure out what led me to make these choices on my crimes. And it just brought me back to my childhood. And it showed me my triggers and stuff, how I mimicked my father throughout my life.
Okay. Mrs. Stapleton is going to ask you some questions in a minute. I'd like to recognize that you have Jessica Bunstoff, your fiance, join us via Zoom who would like to speak. Is that okay if I call him first?
Yeah, absolutely.
And if you would like to go ahead and speak first.
Good morning. My name is Jessica, and I am the fiance of Julius Wilt. Thank you for giving me the chance to speak today. I'm here because I've seen Julius's growth with my own eyes, and I want to share what I know about the man he is today. Julius fully understands the seriousness of the actions that brought him here. He has taken responsibility, and he has spent his time reflecting and working hard to change. I'm not here to excuse his past. I'm here because I've watched him commit himself to becoming a better man. His faith has been a major part of that change. Julius has become a deeply spiritual man, and following Jesus has given him purpose, humility, and direction. We thank God for his growth, his commitment, and the strength he has gained through this journey. While incarcerated, Julius has made the most of every opportunity being there. He earned his GED, completed courses to better himself, and even stepped into mentorship roles to help others. That says a lot about his character. He wants to lift people up, not bring them down. Julius also has a family who supports him wholeheartedly. We believe in him because we see the work he has done. If he is granted parole, he will come home to a stable, loving environment. He already has a job lined up, and we have talked about routines and boundaries to help him stay focused and grounded. He will not be doing this alone. What gives me confidence in Julius is not his words, but the consistency of his actions. He is patient, thoughtful, and committed to living a responsible, rehabilitated life. I truly believe he is ready to continue this progress outside. Thank you for listening to my perspective. I know your decision is important, and I appreciate the care you put into it. I believe Julius has earned the chance to show that he is not the man he once was, and I am ready to support him in every step of the way.
Thank you, Jessica. Now we have Victoria Wilt Navarro, your daughter, who would like to speak.
Hi, thank you so much for letting me speak today. My name is Victoria. I'm the daughter of Julius. Over the last 15 years, I've definitely seen a huge growth in my dad. He is definitely a rehabilitated man and a changed man, and I'm really excited to be able to have this new opportunity with him when he gets released, whether that be now or in the next few years. I know his faith has definitely been a huge part of his transformation and his change as a man. He has shown severe remorse for his decisions that he made in his younger years, and I know that he deeply regrets the decisions that he did make at those times. I'm excited for him to be able to get out into the world again, live a normal life, have a job, get married, and be a part of that life. So I think that this is an appropriate time for him to return to a functioning member of society. Thank you.
And now I'd like to ask the warden. Warden, would you like to make a statement regarding this offender?
So I know, Mr. Wilt has been here for 15 years, that right up in that time frame. He was a mentor in our transition programs for a while until he, backed out to go. He's in HVAC school right now currently. And, yeah, he has been no issue since he's been incarcerated.
Thank you. Yeah, I know you have had 0 write-ups during your time of incarceration. We also have Mr. Randall Meyer with the Jefferson Parish DA's office.
Good morning, Randall Meyer, Assistant DA in Jefferson Parish. We're opposed to his request at this time. There's an extensive history of domestic abuse. The facts of this particular case are pretty horrific. And I won't get into those. That y'all have those on the record, in the record. I know you saw those. But he had 2 charges for home invasion, 2 separate cases. One he got, they were what day apart, 6/8 of 11 and 6/9 of 11, according to the court records. And this is this case number is related to the 24th JDC case number 113730, and there's another one 113731, which was June 9th of 2011, and he was guilty of aggravated assault in that case. I note that his DOC mental health evaluation is concerning. with his diagnoses and the fact it indicates he missed at least 5 appointments during that time. It doesn't state whether he made those up or, you know, what the facts around missing those appointments are. And I'm concerned with his programming. He did a number of programs back in 2015. He had anger management, Inside Out Dad, 2017 and all. He had some, and then he really had nothing after that until the 100 hours in 2021. He did take victim accountability in 21, you know, 1 or 2 other programs with the domestic, you know, the long history of the domestic violence. And I'm concerned with, you know, the only thing he's had relating to his anger issues was completed in 2015 and nothing more. So for those reasons, we're opposed.
I've got a question, Randy.
Yes, ma'am.
When I was looking back over this, I see when we go back to, we've got the 2011 case, but we also have the case that goes back to 2001, I believe. Let's see. And that's where we say the long history of domestic violence to 2000. And on that, there was, it says a charge of attempted first-degree murder. Do you know anything about that, 2002? And then prior to that, we've got stalking, intimidation, violation of protective orders. Are we talking about a different, well, obviously, because this other one, they were only in a relationship for 3 years. So prior to that, seems like we have this other very serious case that goes all the way back to 2000 with a litany of crimes ending in an attempted first-degree murder charges and aggravated assault.
Yes, ma'am. And that is some of the issues that I have. Let me see if I can find, I'm not sure what happened with, I think, you know, though they must have been refused for some reason. The only charges of record in the clerk's office, which I'm looking at as we speak, he had some worthless check charges. In 2000, those are worthless check charges. And I did not see anything related to, you know, I saw he was charged with that, but I didn't see anything, and I still don't see anything in our record that deals with that.
Because, I mean, it's got almost the same type of charges, remain after being forbidden and very serious, like you're saying. This is a long history of domestic violence behavior and very serious domestic violence behavior. And I don't understand why it didn't lead to anything. That's why I was wondering, was he on probation?
Okay, yeah, well, it showed he was billed at aggravated assault.
Yeah.
On that attempted murder charge, 2 counts. He pled guilty and he got 4 months in parish prison on that.
Yeah, I saw that.
Yeah, I don't know the facts surrounding that case though.
Pretty lightweight, huh?
Yeah.
And then I saw where on a DV in the synopsis that he lunged at the police officers with the knife. Was that this last one?
Yes, ma'am.
That was this last one. Okay, let me ask you something else. I'm curious on our end. Okay, any victim like this victim, when crime victims law, that they're not supposed to have any contact with their victim. So when he gets out, is there a way for this to be a permanent protective order for these victims of this last incident?
Well, in this,
ask for it.
That's what we just talked.
You know, I guess you'd have to check with the board's counsel on how far y'all can prevent any type of contact. I don't know if that can go past his full term date, but there is a stay away order until May 24th of 2030.
I saw that.
Yeah, so at least until 2030, if he gets near the victim, he can be revoked. Well, obviously he could be revoked if y'all were to grant him parole for that, but he also could face additional charges by violating that stay away order.
Yeah, because I mean, my thing to an offender is stay away from your victim, period.
Yeah.
You know, that's my thought as a person on this board, that you're to have no contact with your victim, and this person is whoever is the victim. And so that's, I just wanted to ask you about that because I was very curious about the 2000 case and the 2002, because all of these seem to be a history of domestic violence that are very serious cases. All right, that's all. Thank you, Randy, very much.
Yes, ma'am.
Let me ask, and see what we've got going on. Can you tell me, sir, what was in your mind that day that you did this? Because you do have a history of domestic violence.
It's been like I had stated previously about, I didn't get my treatment when I was out there throughout my childhood. Every time I saw treatment at the beginning when I was like 13 years old. My parents were poor. I come from two parents that were molested, that didn't give me any type of guidance. I'm not taking away anything from the crimes that I committed. I'm fully responsible. I mean, I'm totally remorseful, but I haven't gotten the treatment until I got here at Hunt's, talking to the psychiatrists, social workers, and everything. I've been diagnosed with bipolar disorder, depression, anxiety, borderline personality disorder, paranoia. But as of today, I have none of those issues. I have been cleared from the psychiatrist. I have got off of every medication that I've been on because I've come to the terms to understand what led me to react these ways, what triggered me. I watched my father be abusive to my mother throughout my entire life. He's tried taking his life by ODing, cutting himself. And like I said, I mimicked him. And I never understood this. Like when I went to drinking and drugs, I've always like taken classes. And like the DA spoke about, I've actually facilitated anger management classes about self-evaluation and to how to pursue things and catch your triggers before you even act out on certain things. But I'm remorseful. I'm no longer that person that committed these crimes. And concerning the stay away order to the victim, she has written me and I never responded back to her. I showed that I was not going to violate any type of law.
Because you're right about that. The order is against you. And so if a victim does something like that, which they shouldn't, but you are the one that the order is against. So you did the right thing there. I'm very glad to hear you did that. I wanted to ask some more questions. So you said that you're on medication for borderline personality disorder and bipolar. That you can speak.
No, I was. I mean, ever since I left, when I was in Jefferson Parish, went to St. Charles Parish, I was on several different types of medication. I mean, all I was doing with my issues that I've suffered throughout my life from drugs and alcohol, my trauma was just being pushed down. And even being on medication at the institution, I never discovered what my issues were because they were just like, I couldn't starve what was inside me. I mean, because I was just suppressing everything. I mean, to come to really realize what I've done to people. I mean, even with the issue with the police officers, that should have never happened. I mean, I am very remorseful. I put myself in situations and made the stupidest of choices. But I promise you, I am not the man that y'all see on the police reports. I mean, I respect what the DA said about me and how people can view me for the actions that I've done throughout my life. But I promise you, I will be a productive person out there. And I'm willing to even be a part of some type of group to speak to men and women about issues that they suffer and that you can overcome these things. I mean, Christ has changed my life dramatically. I am no longer that man that y'all see.
Okay, I wanted to ask about that also. Thank you, sir.
I have no questions.
Mr. Will, since the Assistant DA brought up, what have you been doing since 2022? What's occupying your time while you're there in the last couple of years?
Well, I had several surgeries here at Hunts too. So that kind of kept me like bedridden for a little while. And I live in a bed storm. We take classes every day. On Monday and Tuesday, I'm a part of a squad where several men get around a table and we talk about things that happen in our life, like from responsible thinking and addiction recovery, relapse, personal growth. Man, I'm a part of a program that, it's from taking mentees to become mentors using the core values of the military.
Okay. All right, I have no further questions. Secretary, you're prepared for that?
Yes, I am. Sir, I want to compliment you. I saw all the classes that you've taken. So, so you've done a very good job with trying to better yourself and learn. I'm very happy about that. But you do have a significant criminal history concerning domestic violence, and it goes back a good ways. Let me ask you, in all your classes, and maybe I missed it, did you take a DVOP class, a domestic violence offender program class, which is different from an anger management class? Anything like that?
Man, I'm in victim and impact class right now, coming to terms with your crime that you committed and the impact that you caused on family.
Okay, all right. Well, I was just wondering if you had that. Today, sir, pardon, go ahead.
I've enrolled into a domestic victim impact class out there in anger management and substance abuse and behavior misconduct for when I'm released. I've already enrolled in it.
Okay, well, that's good to know. That's very good to know. Okay, today, sir, based upon your criminal history, I'm not going to be able to grant your parole today, but I want you to keep up the good work that you've already started. It's excellent.
Mr. Byron?
I'm going to concur with Ms. Stapleton for the same reasons and the strong law enforcement opposition. But keep up the good.
And my vote would be to grant parole. I don't feel like at this time, with the mindset and the classes you've taken, that you present a significant threat to public safety. You've served almost 85% of your sentence. Your rehabilitation has been excellent. Your conduct, 0 write-ups. If somebody has an anger management problem, I think we would see it on the inside. Warden, I don't know if that's true or not, but typically that shows itself. And you do have good reentry plans. So my vote would be to grant. But on a vote of 2-1, your request for parole has been denied. And that concludes our hearing with Mr. Wilt. And the time is now 9:51, and we are wrapping up at Elaine Hunt. Thank you, staff.
Denied. So Michael does the emoji math for us. 2 denied emojis plus 1 check mark equals a denied emoji. Thank you for doing the math for everybody. Couple of things that stood out for me. First, there was the mention in the chat of the phrase that we have coined here, the Jesus blanket. I don't think he used the Jesus blanket here. He mentioned his faith, and his wife or daughter or somebody mentioned it as well, but I didn't get the impression he hid behind it. The Jesus blanket, in my definition of it, is used as a cloak. Like, I committed these crimes, but Jesus has saved me and everything's all good now and great. I don't think he did that. That's not what I heard. So I don't know if this is a Jesus blanket case. But one thing that caught me, and this catches me all the time, and I'm just so sick of it. Do me a favor right now. Put a 1 in the chat if you went through your entire childhood and you were not messed with by anybody in any way. Just perfectly clean. No issues. Nobody ever did anything to you. It was buttercream and roses. It was little bunnies jumping in the woods, as Fleischer likes to say. Put a 1 in the chat if that's really what it was. I'm frozen again? Doggone it, I tried to fix that the other day. All right, hold on while I wait for you to put your ones in the chat. Tim, I don't believe you. I could be wrong. So not many ones in the chat. This is my point. Everybody hides behind the whole childhood trauma thing, the childhood trauma. You know, somebody, well, you know, my mommy and daddy didn't hug me enough when I was a child, or, you know, sometimes we struggled for food, or I was one of 22 children and I just didn't get enough love. I'm so tired of it. Just stop. And this guy tried to do that, and I'm sick of it. It's just not real. I mean, all of us are still going on about our days, and we're not committing crimes because of something that happened to us when we were 4 or 5 years old. We're just not. I'm just saying. Anywho, enough of my lecture. Let's go back to Judge Boyd, because that defendant she was going to think about is back.
Robert Featherston representing Mr. Dixon.
And you're Mr. Dixon, correct?
Yes, ma'am.
Let me see. All right, Mr. Dixon, I've had a chance to hear hear testimony from all parties. And what I can tell you all, my issues and what I'm going to do, and I'm going to give you 2 choices. There are no other choices. Don't ask me for any other choice because these are your only 2 choices. Number 1, someone who has Child Protective Services history, the abuse that he's had from his family. That's why he was in CPS care. And I understand that CPS workers are overworked, underpaid, and they don't have time to go out and visit everybody, but their jobs are so important because a child could die if they don't do certain things, right? And then I understand that when he is 15 years old, he's certified as an adult. And that's a person who's certified as adult, sent to prison for 15 years. And all that entails, and I keep telling people, prison, it would be so great if you go to prison and everybody left you alone, everybody's there to be rehabilitated, but sometimes that doesn't happen. Sometimes inmates get killed by other inmates in prison. Sometimes inmates get raped by other inmates in prison. And sometimes when all of this happens, nobody wants to talk because they'll be labeled a snitch and they're still in the same environment that they're in. So I'm taking all of that into consideration. So these are your choices. Don't ask me for any other choice because there's no other choice for you. 1, I'll grant your application for deferred adjudication. And let me just tell you why I would grant that. With a deferred adjudication, which I've already told you and I've told your attorney before, if you were unsuccessful, you're looking at 99 years or life sentence. Or I will deny your application and I will sentence you to 6 years in the prison. And what I can tell you is I will be following the recommendations that are in the evaluation, which is saying that he is to go to SafeP. And when he is released from SafeP, he's going to be on full GPS unless he shows the court that he has employment, and that GPS will be there to protect the community. And we will see about his receiving mental health treatment evaluations to see if DDRF is appropriate for him or not. But either way, he's either going to be doing the time at the prison, which you can do that, or you'll be on deferred adjudication. Do you need to speak to your attorney about that?
To take the probation.
All right. Thank you, State. Okay. And State, is there any restitution that is owed?
Judge, not to my knowledge, but I would have to talk to the thing, but it's.
All right. So what we'll do is we'll also set it for a restitution hearing in 30 days. Can I have a 30-day hearing for restitution?
March 16th.
All right, March 16th, that'll be the restitution hearing. So the court is going to sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, follow the TAP recommendation of SafeP. So he's to remain in custody until transferred to SafeP. In probation, see maybe if felony drug court would accept him, because I see the cocaine use and meth use started at 11. So we will do that in a referral to felony drug court in custody. And if we can do the MHI for him as well. There's to be proof of employment within 60 days of release. No employment as a home health care provider or with minors. No residing in households with minors. Take in consideration 2025 CR 001601, 2025 CC 014159. There's a $2,000 fine that will be probated. There's going to be 300 hours of community service restitution. I'm going to require daily sober support meetings. I think he's going to need a lot of structure.
He is, Judge.
And there'll be an hour deducted for every sober support meeting completed from his community service restitution hours. And there's going to be field visits 1 time per month until further notice. Probation, and then upon release, there's going to be full GPS, waive fees, and that will be until further notice. And probation with regards to the GPS, of course, if he has employment or he has to report, he's allowed to do that. Probation, is there anything else?
Sorry, the mental health you said upon release, right?
Oh, I'm sorry. Let me put on my glasses so I can hear. Yes.
The mental health caseload upon release.
Yes.
Okay, nothing else said.
Thank you.
And Judge, we would also ask for a no contact order be in place with the.
All right, there's to be no contact with the complainant.
And also with the arrest.
Yes. Let me find that. And with, let me see the location in here. Oh, that's 7150 San Pedro Avenue, 78216. And Mr. Dixon, how far did you go in school? All right, so you're going to need to obtain your GED or some type of trade certification, something to help him with his employment abilities.
May I address the court, Your Honor?
Yes.
Judge, his reading level is at 3rd grade.
Okay.
He does need to work on his GED. If that program is available while he's in custody, I'd recommend that the court consider adding that as a condition.
Okay.
Judge, we broke this man. Society broke it. If the court would consider a very high form of supervision for him.
Yes.
Also, the court might consider maybe monthly or bi-monthly status checks with the court to find out where he's going.
All right, and will you remain on the case?
I will, Your Honor.
All right, Ms. Abrams, upon his release from safety or felony, if he's in felony drug court, they're gonna keep very good track of him. If he's not in felony drug court, then what I'll do, and I've done this before, where have them come in every 3 weeks and we lessen it the better that they do. But no, I would appreciate it if you would stay on it because I do not have the capacity to keep track of every case, but we can, if we're able to set it for status updates, then I will do it. We've done it before.
Appreciate that, Your Honor. If he does get transferred to drug court, maybe that won't be necessary. However, I'm certainly willing to go to drug court for status conferences also.
Oh, yes, if you would do that, and if you would get in touch with a felony drug court to let them know what his issues are, and they have a dual diagnosis and they'll address all of those issues.
Thank you.
All right, and so then we are coming back on, what day was that for was it March? All right, so we're coming back on March 16th to see if there's any restitution. All right, is there anything else?
I thank the court for its time.
All right, did you review the documented, I'm sorry, is there anything else that you need from the court?
No, ma'am.
All right, so this is what I can tell you about obtaining the GED. I teach at UTSA, right? And I try to give them tests that are part of their skill set. So sometimes it's multiple choice, sometimes it's essays, sometimes it's true false. I understand that sometimes people are not good test takers. So whether or not they successfully complete the GED, it really doesn't tell what they know. So if there is an issue with your completing the GED, your attorney will let us know. That's why I said GED or some type of trade school certification, because you need to work on your employment ability or ability to obtain employment, okay? All right, did you review the document titled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am, that I cannot appeal the decision.
No, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, in this court, to be successful in probation, communication is key. If there's an issue, you need to let your probation officer know about it. Mr. Featherston is going to continue to stay on your case. If you feel they're not addressing it, you or Mr. Featherston can come back and address it with the court. Do you understand?
Yes, ma'am.
All right, and we're off the record. Here's the thing. Tattoos. No more face tattoos. And the reason why is because people are like books, right? And when I go into the bookstore and I'm looking at the books, the first thing that attracts me is the cover, because you're like, that's an interesting cover. And then you'll open up and read it. Well, sometimes for employment, when they see face tattoos, they think this is a book I don't want to read. So they don't even really consider you for employment. So stop the face tattoos. All right. And then at some point in your life, I understand you had bad parents, maybe Child Protective Service didn't do what they needed to do. Bad things happen in prison. But at some point, your decisions, they're going to start being 100% your decisions. You can't keep, saying, I'm doing this because this happened to me or that happened to me. And I'm giving you all the tools that I have available to help you become who you were always meant to be. All right. Good luck to you. Okay.
My uncle said he seen you at Papado's not too long ago.
All right. Let me just tell you, crab fingers at Papado's, great. I really wish they would bring back the lobster salad. They told me their owner went to Greece and came back with this different salad. I'm like, bring back the lobster salad. If I was like Norma Ray, I would stand on the table with a sign that says, bring back the salad. Yeah.
That's good.
All right. Thank you.
Thank you, Judge.
Thank you. Is there anyone else who's ready?
Mr. Dix.
Oh, hold on. There we go. Can confirm we have a Papados here in the greater Phoenix area. And yeah, lobster salad. Good. So listen, I understand why this guy took the 10-year deferred because of what he went through in prison before. The problem is we know the success rate of that. However, I was impressed by the fact that this lawyer wants to stay on the case. He was recommending a monthly or a bi-monthly follow-up. There might actually be a chance here. So fingers and toes crossed. As the guy said, you know, society broke him, we broke him. And Boyd wants him to be the man he was always supposed to be. So maybe, we'll see.
Yes, in Houston.
Oh,
It's at Gate E.
yeah.
But you know what? They still won't bring back the onion rings. It went away during the pandemic and they don't have them
They
anymore.
were good. Their alligator, Barbados is great.
Yeah. All right. Hello. Court is calling 2024 CR 4101 State versus Gina Romano. Can I have parties announced?
James Tochi for Ms. Romano, Judge.
And are you Ms. Romano? All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Gina Romano who's placed on deferred adjudication in 2024 CR 4101 for the offense of possession of a controlled substance penalty group 1, 4,200 grams on January 9th, 2025 for a period of 5 years? Is that you?
Yes.
All right, state.
Violated condition number 4. In Bexar County, Texas, the defendant Gina M. Romano did that and there failed to report the supervision officer as directed in the months of February and March 2025 in violation.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
If the proposed agreement is to deny the state's motion and alter and amend to add 90 days as monitoring, there comes which of these 90 defense.
Yes.
I mean, we're in agreement on the recommendation to the court. I explained to Ms. Romano what that entailed. One request I would have is if the court can waive those fees, if the court is willing to go along with it. She did get off to a very poor start, Judge. She has a couple really good reasons why she turned one. At the same time, she had a sick mother who is, as I understand it, she is still in a coma. She fell into a coma the day she was released from jail, Ms. Romano. She works, she has a husband, she's far more stable now than she was a year ago. And so I hope the court will allow her to kind of begin again on her probation. You will have tabs on her. She does work, she does care for her child, and she is prepared to follow the orders of the court.
All right. Any objections to the court reviewing the court summary?
No, ma'am, not at all.
So how was she arrested somewhere or did she turn herself in?
Don't know on the MTR.
Mhm.
MTR, my husband and I turned myself in. I called the police to my house.
All right. Do you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
Gina.
All right. So how did you become aware of that there was a warrant?
I had called the non-emergency police to see if I had a warrant.
Okay. And then, and
I
what,
knew that I didn't do my probation.
and did they tell you you had a warrant? And then what did you do?
And then we made the decision for me to get this handled and taken care of.
I'm sorry, I can't
And
hear.
then we made the decision for me to get this handled and taken care of. So it's not like over my head.
And how did you make a plan to do that? What did you do?
I decided to turn myself in, to just call an officer to my house to arrest me, so I could come and have this handled. Ask for a second chance. That's what I'm asking.
Oh, okay. And you've been missing for a year. And according to this, they said you were granted probation on January 9th, 2025. released from custody on January 13th, 2025. And nobody saw you after that. Explain.
I just started my business. As my attorney said, I had just had my baby on November 11th of 2024. And then, so he was very young. I was taking care of him and starting my business.
So why didn't you tell probation?
I just had my priorities up, and in the year of taking care of him, in the year of starting my business, my husband and I we have a house rather than an apartment. So when I came out of jail last year, we were in an apartment. Now we live in a house. We have a car, a truck, 2
See,
motorcycles. He
here's the
has
thing. You're telling me all of this as for reasons why you should not be revoked and go to prison. But you're not explaining to me why it was so difficult for you to go to probation, report, to pick up a phone and call probation and say, hey, probation, I have this that's going on in my life. Everything is hitting me all at once. And you know what probation would have said? Take a deep breath, come down and report.
I understand. That was my mistake.
I mean, not mistake. Those were your choices. So I'm trying to figure out why I should not revoke you. You're telling me about all of these. Well, I have a home now. I have a child. I'm ready to do what's what. That's you throwing yourself on the mercy of the court. And I used to be a defense attorney, and I would always tell my clients, what you're giving me is just throwing myself on the mercy of the court on your behalf and saying, please, judge, don't sentence me. But I have nothing. Now, I will tell you one thing that's in your favor, and if your attorney is telling me it's true, I'll accept it as such as the officer of the court, is the fact that you picked up the phone to see if you had a warrant and you called the police to come to your home to pick you up. That's one thing that's in your favor.
I didn't ask her about that, Judge. I mean, I believe that information is probably easily verifiable if that's the way it went down. I believe Ms. Romano.
All right, does anybody want to verify that for the court?
Ms. Romano, do you recall the date at which you called the police to tell the police?
It was, I think it was January 20th, 19th or 20th. I believe it was January 20th. It was the husband.
Your hope, I guess your address was your home, correct?
And yes.
All right, so they said you called the police to come pick you up. That's a good thing. That's a thing in your favor.
Yeah.
Probation, I'm sorry, state, what are you requesting?
We're asking you to follow the agreement and let's give Ms. Romano a second chance, given the circumstances and restriction not apply. All of that.
All right, so this is what I'm going to tell you. One, I don't think GPS is appropriate, but you do need to have some form of punishment because you've been missing for a year. And that form of punishment is going to be that this will no longer be a deferred adjudication. This will be a guilty verdict. So I'm going to give you a choice. You only have 2 choices. Don't ask for a third. 1, I am going to find you guilty, place you on probation. Or 2, I'll sentence you today and I'll sentence you to 2 years.
I think she wants the probation, Judge.
All right, this is what the court is going to do. The court will find you guilty. The court will place you on community supervision. Court will sentence you to 5 years in the prison, suspended and probated for 5 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days of release, no employment as a home health care provider or with minors. Are there any drug issues with you? All right. There's going to be field visits 1 time per month for 8 months. There's to be 200 hours community service restitution. 100 of those hours will be deducted upon completion of parenting classes, which I'm ordering. Probation, is there anything else? And on a previous probation, there was no, you know what? We can go ahead and do a TAP evaluation out of custody.
Yes, Judge. Judge, I would like to have her report weekly or monthly.
All right, weekly reporting for 60 days. Is there anything else, probation?
No, Judge.
Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing, in this court, if you have an issue, you need to let probation know. All it is a phone call. If you feel they're not addressing it, you can always come back to the court and address it with me. All right, good luck to you. They'll probably release you maybe off the record. They'll probably release you maybe, I don't know, midnight. I have no control over the release from the midnight.
There's no
Yeah.
chance for today. No chance for today.
No chance for what?
I work down there.
Yeah.
Hopefully tomorrow.
Yes, so that's usually what happens.
Being honest.
All right, when you are released, the first thing you better do is report to probation. All right, thank you. Good luck to you.
Have a seat, ma'am.
Okie dokie, friends. It's a few minutes early, but we're going to call it a day here because I can't afford to go long today because shortly after the noon hour, my time, Mrs. TCF has her first day of physical therapy. So we want to make sure we make it to that on time. But we will be back here tonight, 8 p.m. Eastern, 5 Pacific for Sidebar, where we're going to do a deeper dive into the Tiffany Woods case that we saw on TCF a couple of days ago, the parole board, and that whole thing. So we'll dig into that and see how that goes tonight. And we'll be back here tomorrow morning for our Friday show. 9 a.m. Eastern, 6 Pacific, a half an hour earlier for channel members. I hope you all had fun today. I know I did. I look forward to seeing you all hopefully tonight and definitely tomorrow. Take care. God bless.